Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun, enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Michiegas. Ridiculous that insanus. Oy vey, Marcus. Proceed, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know, cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello. Hi. Hello, my friends. Thanks so much for coming to hang out with me tonight. Today's Monday, November 10th. Monday, November 10th, 2025. Tomorrow's 11/11. It's the 11/11 portal. Did you guys miss me? You know, I always tell you that I won't tell you where I'm going, but I will tell you where I've been. And so I've been busy. I've been busy. It was a parents' weekend at a college somewhere is all I'll tell you. But that's where I was. And so, you know, I had my equipment with me and everything. And I was waiting because Friday the briefs were due, or the Commonwealth brief on Shawn Souza was due. So I had all of my equipment. And I thought if the brief drops, if the Commonwealth files their brief to overturn the see, I'm already a couple of days off, and I'm already like in it, back to it with the craziness. I forget what I was going to say, because now I have to put my phone on do not disturb, so people do not disturb me when they clearly are watching me and they know that I'm on the air like this actual very second. Shawn Souza is the former Dartmouth police officer who was tried twice for the grape of his stepdaughter, who was, I think, between 6 and 8 years old. Tried twice. The first trial resulted in a mistrial, and the second trial resulted in a conviction. A jury convicted him of the grape of his stepdaughter and of essaying another girl who was 15 years old, who was a family friend. He was convicted, I think, the second time, 2024-ish, I want to say. And then what had happened was the judge in his case overturned the verdict and said, you know what? The same judge who tried the case for the second time, the judge overturned the verdict and said, you know what? I think Shawn Souza deserves a new trial. I think he deserves a new trial because we shouldn't have had both victims tried in the same trial. Even though the jury convicted him and I sentenced him, the judge actually had sentenced him. And I forget what the sentence was right now, so don't hold me to all the details right now. The judge sentenced him and then overturned the verdict for a reason that the defense did not even argue. His attorney was Kevin Reddington, I believe, right? Am I getting the details right? And anyway, the judge secretly let Shawn Souza out of jail. Just let him out of jail. Nobody knew. It was around the holidays and nobody was paying attention. And so the district attorney said, hell to the nah, I'm appealing this. And so the briefs were due on Friday. And then as I was waiting for the briefs to come out, I found out that the Commonwealth made a motion to the court to get some extra time to brief Shawn Souza's case. And if you are not outraged by this case, what are you doing? Like, it is one of the worst cases in Massachusetts, if you can even say that. But I did find out that the briefs are now due December. I think it is, I have it in my calendar for December 5th. So we will see the briefs on Shawn Souza when they came out. But what I do have is the KELSEY FITZSIMMONS brief. So I have that because that was due today. And so I have that and it's here and it's going to be a cold read because I just literally got it in my inbox 5 minutes before I was going to go live. And I set this live for 5:30 today because my flight was supposed to get in 2 hours earlier. It was a 2-hour delay, but which is lucky for me because I think there are other people who have flight delays that are far worse than the 2 hours that my flight was delayed today. And that is because of the, as such, shutdown of the government and the fact that, the air traffic controllers aren't getting paid. So I did fly into JFK. Luckily, I flew out of a very small airport, but it's been planes, trains, and automobiles for me today. So here I am. Only a minute or two late. So I hope I didn't inconvenience you too much. And what I will also say is a crazy thing happened on the way to the parents' weekend because it was not in Boulder. I saw some people putting in the chat that it was in Boulder. I will only tell you that it was in the Low Country. It was in the Low Country, somewhere in the Low Country. And big shout out to Paulette. Paulette at my hotel works at the hotel where I was staying. And I had gotten out of the shower. I was in my bathrobe and there's a knock on the door. And I'm like, okay, what's up with that? I didn't order any room service. I have, every do not disturb sign possible on my door and light on. And I answered the door and there was like room service. And she said, oh, it's your birthday? And I said, no, it's not my birthday. And she said, well, I have this for you for your birthday. And of course, it was like a giant cupcake that said happy birthday on it and chocolate covered strawberries and a note from someone at the hotel named Paulette who said, we're so happy you're staying with us. I just wanted to tell you, I really love your YouTube presentations. I was like, oh my, are you like in the Low Country? In the Low Country, someone knows who I am. I was floored by it, but I had to go find Paulette, to make sure that the Massachusetts State Police were not actually stalking me. And it was like, it wasn't a message to say like, we know where you are. But Paulette really did exist and she did work in the hotel and she sent me a cupcake, which was my own special way of saying, okay, I think she really does know who I am. And she was thrilled. And she did say to me, she said, you and Emily Baker and Peter Tragos are the only people that I watch on YouTube. And I love your show. And she's like, I hope you didn't think it was weird that I sent that to you. And I'm like, no, that's so awesome. Great, Paulette. That's amazing. She happened to be like working at the time and she was working at a desk in the lobby. So she couldn't really take a picture or anything. But if she's watching tonight, thank you, Paulette. You made my day. And it was fun. And aloha to Maui. Hey, Jennifer, what is up? I wish I was in Maui. But I'm here with you guys, which is just as good. It's just as good. So I thought that was kind of cool. I was like, I'm in the Low Country and somebody knows who I am. So we are everywhere. You are everywhere. The world is watching and you are the eyes of the world. Wake up to find out that you are the eyes of the world. You are. And I mean, what did I miss? What did I miss? There was no breaking news. So I didn't feel the need to like step away from my family obligations and go live with anything. But Paulette's a cupcake. She is. And so I thought that was really cool. Great story, right? Great story. And that reminds me that I am watching the Murdaugh documentary not documentary. It's a fictional account of Murdaugh, starring Patricia Arquette, who is just everywhere, including Severance. And we love Patricia Arquette. And so are you guys watching it? Are you guys watching it on Hulu? So Low Country is where the Murdaugh case happened. The Murdaugh family, the dynasty of the Murdaughs ruled the Low Country of South Carolina for 100 years. And that is why, nobody wanted to speak out against the Murdaughs because they were a very, very powerful family, similar to, the very powerful family in Massachusetts. Ms. Holmes is like, nope, it was a couple of boring days on YouTube, you guys. It was boring. And Team Brittany says, not so fictional, stay away from South Carolina. Oh, well, I'm just saying, Alec Murdaugh is very upset about it. He thinks a lot of liberties were taken. Some of the lawyers, I think, involved also think some liberties were taken. The timeline was a little screwed up and whatnot. But I'm not saying not that there's not corruption in South Carolina. By all means, there absolutely is corruption in South Carolina. But what I will tell you is that if you are watching it, that the actor, and I want to name him because he's so good, the actor who plays Paw is amazing. He is so good because let me tell you what a really hard thing to do as an actor. It's a really hard thing to make a not so sympathetic character be sympathetic. And the actor who plays Paw or Paul Murdaugh in this miniseries, which is on Hulu, and his name is Johnny Berchtold. And shout out to Johnny Berchtold, man, for making Paw a very likable and sympathetic character. Am I right? Am I right? Here he is. Let's put him up. Let's give him some credit where credit is due, eh? Here's Johnny Berchtold because props to him, and I maybe Emmy nomination in his future. I'm gonna call it now. I'm gonna call it early. Here he is. Here's Johnny Berchtold as Paw in this. Does he really only have one picture on IMDb? Wait, hang on. Oh, he was in a movie with Rob Lowe. Look at that. Doggone, it was called. But he doesn't have a ton of credits. Let's see what else he was in. So the miniseries, if you have not seen it yet, is called Murdaugh, Death in the Family. It is, there's 6 episodes out so far. I'm caught up. I think there's 6. I'm caught up and it's good. It's good. I like it. I like Patricia Arquette. I feel like she can play every character. He's been in a couple of shorts. He was in a couple of episodes of Reacher. Let's see, 8 episodes of Reacher, which is another show that I did not see. 3 episodes of Tiny Beautiful Things. And so he's relatively new. I don't know how old he is, but I'm just going to say, I'm going to call it now. Emmy nomination for Johnny Berchtold, who for playing the role of Paul Murdaugh. It's good. It's good, actually. I did not watch the other one. There's another one out too, but I didn't watch it. And I'm also caught up on Tulsa King, which I also like. I mean, when I first started watching Tulsa King, I thought that Sylvester Stallone was just going to be a joke, but he's really good. Except now, Tulsa King is just getting a little bit unrealistic, in my opinion. Like, it's just really, really. And also his daughter is in it now, and she's just, I mean, no shade, but she's just not a great actress. She's just not. Her name is, I think, Scarlett Rose Stallone, and she's just not a great actress. Sorry, I do like Lioness. I did, and I watched Lioness in full, and I loved it. Is there another season out? Hang on. I'm parched and literally just walked in from like getting off trains, planes, and automobiles. But I had to set up all my equipment because it was all packed away. Hold on. And so there's that. But I do like Lioness, and I didn't. Is there another season? Yellow Jackets, I love. I always will love. I always will love Yellow Jackets. I will finish it until the end, Amy. I'm here for the duration, and I'm going to finish it. And I love Landman, and the new season's not out yet, but if you haven't watched that, watch it. Frankenstein, I have not watched yet. Thank you. Thank you very much, Rebecca, for giving me another thing to watch. That's awesome. Season 2 of Landman drops next week. Are they going to do it like once a week? Because that's kind of like what they're doing with the Murdaugh thing, which I'm kind of liking it now. I'm kind of liking like my morning show. I'm caught up on the morning show. I love the morning show. In fact, my mother says, because my mother loves the morning show and my mother also loves me, and like her way, she's met a lot of famous people in her life, and she says that she's going to write a book called Famous People Who Have Met Me, which I think is a great title for a book for my mother to write. But also she says to me that she loves the morning show too. And she says, you know what, Melanie, she says, Jennifer Aniston is completely imitating you in the morning show. And I was like, oh my God, that's so great, Mom. You're the best mom ever. You're the best mom ever. So I think that's funny. I need a little lipstick. I don't know what's going on here. It's a whole thing. Anyway, how are you guys? How are you guys? I haven't talked to you in 5 days. I got so much to say, so much to say. In addition to the fact that Moselle is for sale, you guys, did you know that Moselle is for sale? So for those of you who are watching, the Hulu show on the Murdaughs, I'm going to tell you, oh, baloney. Oh, so Team Brittany says in an undisclosed airport, maybe we were in the same airport. I met a dude named Michael wearing a Dave Matthews Band hoodie. He was on his way to Jacksonville to see Sting. Sting just canceled his shows. I hope he didn't get there because I heard Sting just canceled his shows. Sorry to your friend Michael from the airport. Moselle, you guys don't know about Moselle? Moselle is the residence of the Murdaughs, where the murder of Maggie and Pawpaw Murdaugh took place. It is the estate. Somebody bought it. Somebody bought it and they redid it. And we're going to look at it because that's what we do here before we get into the KELSEY FITZSIMMONS briefs. Because that, for me, is 36 pages of reading to you, which maybe it's a little bit less. Moselle is for sale. So if we all want to chip in, we can buy Moselle. Here we go. There it is in all its glory. Somebody bought it and they put about $1 million into renovations. I can't play the video because it's got some, it's on 48 acres of land. It is on the market for, oh wait, did it just literally sell? Because when I looked yesterday, it was on the market. When I looked yesterday, it was on the market. So I don't know if it sold, but it was on the market for 2.2. And they gutted it and they redid it. I mean, it's a murder house, but you know, I mean, I guess if you could get a good deal on it, right? It's 48 acres in the low country. Unless there's a different listing that still has it for sale. This may have been before the renovations. All you gotta do is go Google Moselle, Moselle. Might have been before the renovations. Because I saw a new listing like yesterday. It's 4147 Moselle Road in Islandton, South Carolina. Oh, and it is for sale. Let's see, I was right. It is for sale at 2.2 million. So if you guys want to all chip in, we could go in on it together and maybe we could, you know, we could rent it out. We could do, you know, murder tours and stuff. Yeah, they've totally redone it. There it is. Lots of photos. 48 acres. I don't know if they tore down the kennels though. The kennels, if you have followed the Murdaugh case, the kennels is where the murders took place. Yeah, I know. They weren't murdered in the house, but it's still a murder house. I don't care what you say. It's still haunted. It's still haunted. And you won't convince me otherwise. And there it is. I don't know if they've changed the exterior much. They tore the kennels down. Oops. Somebody said. I mean, it's a beautiful property. I don't know how much the taxes are. There's a horse right in the front lobby. I bet the person who bought it got it for a song because, you know, murder house and all. Alec Murdaugh needed the money to pay his lawyers, I'm sure. Oh, look, the master bedroom closet where Maggie hid the pills and the gun. If you watch the Hulu series, you know what I'm talking about. I wouldn't want to live there. But, you know, for 2.2 million, I don't know, is that a deal for 48 acres out there in the low country of South Carolina? You tell me. You tell me. Yeah. It has stables too. It has a bunch of paddocks. And it's a horse property. It's a horse property. It's kennels. It's a kennels property. I had a whole list of other things to talk to you about. Like P. Diddy making toilet hooch, like Sarah Boone. Like the fact that the Michael Mosher cold case is really a cold case. So apparently Proctor and Kevin Albert were actually really maybe investigating a cold case. I'd like to see the interviews that they did, but there is a cold case that did exist. for a man named Michael Mosher. So that has been confirmed. The mainstream media is a little slow picking up the, Proctor might be involved in 19 other cases thing, because we covered that like a week ago and they just started covering that like 2 days ago because we read the papers, and in the papers in the footnote, there were like 17 other cases listed. And we're like, yeah, we know about that. What else? What else do we have? I have a whole list here. Some of the things that have come out in the Corri Hopkins document dump, because she got a whole bunch of Freedom of Information Act emails and stuff, hundreds and hundreds of pages. Some emails from Tully to Proctor and Bukhenic after he got the defense witness list saying, research who these people are. It's commonly done by prosecutors and lawyers. I don't know if it's so much commonly done by investigators, but are you really shocked? Are you really shocked about that? No, I'm not. The Golden Bachelor. Oh, the Golden Bachelor is on my list too. Did anybody watch the Golden Bachelor on Wednesday? We got totally ripped off. First of all, I thought that was going to be the finals. I thought that was going to be the end. I thought there was going to be a proposal, and then they hoodwinked us. And then the fantasy suite thing with Cindy didn't even happen. It didn't even happen. They didn't even talk about the fantasy suite. So that was a buzzkill. Now I got to suffer through another one of those episodes of the Golden Bachelor. And yeah, there was some big press conference today. Jeffrey Noble of the Massachusetts State Police came out and he gave a press conference. It was like 38 minutes long. I listened to the whole entire thing. They arrested 56 people on child pornography charges, and 55 of them were men. One of them is a woman, and it was a sting operation, and it was set up, and we're not going to watch that either, but you can find it if you want to. But I'm not going to cover that with you, because now we have the KELSEY FITZSIMMONS brief that we're going to read together that was filed for the full panel of the SJC. But first, I'm going to finish my list with things that I wanted to talk to you about briefly. So the district attorneys that were involved in that sting operation that I was just telling you about, the child corn, because I have to say corn on YouTube because it's stupid, but that's what they make us do, was the Worcester DA, Joseph Early, and there's a Berkshire County DA whose name I can't read because I wrote it down, Shagru, maybe. He was involved in it, and they arrested a whole bunch of people and stuff for that. Imagine if they did that kind of an investigation into the murder of John O'Keefe, a fellow Boston police officer. Could you imagine if they did that kind of an investigation into the murder of a fellow brother in blue? We might actually know who did it by now. We might actually know who did it. Did I see Bradle's update on KELSEY FITZSIMMONS? Well, I have the brief here. Is there anything different than the brief? Bradle's brief was due today, and then the Commonwealth has until the 20th to file their brief. And so what we are going to do now is look at the brief. And so, no, I don't, unless it's something different than that. I do not know. Hold, please. Yes, Timothy Bradle says that the clerk of the SJC just accepted our brief seeking Kelsey's release on reasonable bail terms. So the brief has been accepted. That's all that means. That's the update. I've got the papers. We're going to look at them. Okay. We're going to look at them like right now. Okay. So this is the brief to the Supreme Judicial Court in the KELSEY FITZSIMMONS matter. Okay. Hot off the press because this is one of the most important cases that we're covering right now, because we have funneled our outrage into other cases. Some of them are in Massachusetts, some of them aren't. Some of them are in Arkansas. One of them is in Oklahoma. And it turns out that guy, Jesse Butler, I heard rumors that they might be convening a grand jury on him. So not so fast, Mr. Jesse Butler, who almost killed a girl in Oklahoma by choking her to death after raping her and another girl, and then got a little slap on the wrist and like 1 year of counseling, and he's going to be let go, even after he was supposed to be sentenced to something like 80 years in prison, because little loophole, he was 17, and so there was that. Oh yeah, let me just put this to rest, okay? Okay, there's been a lot of rumors. People have been sending me frantic emails and sending me screenshots of frantic tweets that say that Michael Marcy is trying to have Corri Hopkins disbarred. No, he's not. No, please Please do not run rampant with speculation. Okay. Corri Hopkins is an attorney from North Carolina. She filed a lawsuit to ask that the sidebars be released in both Karen Read trials. Okay. The Commonwealth has filed an opposition to that motion, and they said she's not really a pro se litigant. She's really actually an attorney in North Carolina. Here's her bar license. Okay. Just chill. That doesn't mean they're trying to have her disbarred. So everyone just please take a step back. And that is not true. That is not accurate. They are not trying to have her disbarred. No, 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 no. She went off Twitter because it's a cesspool. And she needed some time to do her response and do some actual real work instead of being attacked and trolled, probably on Twitter, which is probably what happened to her. I don't know if that's what's happening to her, but I do know that she voluntarily deactivated her account or whatever you got to do on the cesspool of Twitter to just make it like dormant, I guess, for the time being while she's actually working on some real work. And really, who needs it? The second they started coming for me, and they know what they did, I went off of there, but quick, because I don't need that in my life. And I'm sure that she doesn't either. However, they are not trying to have her disbarred. So please just take a step back. What the Commonwealth is saying is we need clarification from Judge Cannoni about whether or not these things can be released. And Corri Hopkins, you're an attorney in North Carolina. You don't really have standing because this isn't really an emergency because, you know, there's still a motion pending because Damon Seligson, Karen's attorney, made a motion to unseal the sidebars, and that has not yet been ruled on, Corri Hopkins. So why don't you just wait for that motion to be decided? And also, you know, we have privacy law, whatever. I don't know, whatever bullshit reason they're giving her, but they're not trying to have her disbarred. So everyone just please take a step back. It's okay. It's going to be okay. All right. It's going to be fine. She's going to be fine. We're all going to be fine. Whether or not they release those sidebars remains to be seen. My guess is what they're going to do is they're just going to rule on Damon Seligson's motion, and then that will make Corri Hopkins' motion moot. Okay. There's no reason to seal those sidebars forever in the Karen Read trial, in my opinion. There's no reason for it. Karen Read herself is asking that they be unsealed, and they're going to need them for the civil case, I'm sure. And there's no reason to keep them secret. All of those sidebars are part of the official trial record. The public has a right to see that. And so it is my opinion, my legal opinion, that they will be released. Maybe not by Corri Hopkins, because the Commonwealth might want to save face and just grant Karen Read's attorney's motion. Then they'll be released. Then it will all be settled. Okay. So nobody's trying to have her disbarred. She's not going to be disbarred. Everybody just relax. Thank you for coming to my TED Talk. Okay. Moving on. Yeah, they could unseal all except the juror names. Yeah, sure. There's stuff that should remain private, like jurors' names. But listen, how many of those sidebars we know, because we sat through 2 seasons of the Karen Read trial, how many of those sidebars were about the jurors? What percentage? Maybe 1%. Here's the other weird thing or unusual thing about the Karen Read trials, both trials, is that because Judge Cannoni ruled before the trials started that no attorney was allowed to state grounds for their objection, nearly every single objection on grounds had to go to sidebar, which is highly unusual. And so I don't know if Zoe is here today or Zoe is our resident statistician. I don't know, Zoe, if you kept count of how many sidebars there were during each trial, but it is my my guess that they are way, way more sidebars in Karen Read's trials than other trials in Massachusetts. Because that's the way the judge wanted it. That's the way she wanted it. Nobody was allowed to state grounds for their objections. And out in the real world, where real lawyers practice real law, it is required that you state the grounds for your objection. And here in New York, if you do not state grounds and you just say objection, the judge will stare at you until you state your grounds, because that's the way it's done out there in the real world. Okay. Oh, you did count the sidebars, Zoe, in trial number 2. What do you got, girl? If you come up with that number, let me know, because I'm highly curious, because I'm very curious to know like what the average sidebar number is in a regular Massachusetts case. We've watched other trials in Massachusetts and Michael L. ran out of grains of rice counting all the number of sidebars, right? How will we cover them when the time comes? Well, we'll read them. Maybe we'll do a dramatic reading. I don't know. Maybe I'll cast some people and we'll have actors come in and do it. We'll see. We'll see. They got big problems in Massachusetts, and that's just one of them. But everyone just Corri Hopkins is going to be fine. She's wicked smart, and she's an attorney, and they're not going to, just because she's an attorney doesn't mean she can't file a lawsuit pro se in another state to try and have something unsealed. And look, Emily C is here, and she volunteers to be heck. Done, girl, done. All right. I don't know if Zoe came back with a number, but if she does, Zoe, email me, because the chat is flying, girl, and I won't be able to see it. All right. Are you ready now? Are you ready? Thank you. Yes, wise old owl. A little late, but it is an actual murder house. I think that means you meant to say Moselle. Remember, the maid was killed on the front steps. Yes. And that is another thing that I really, really like about this Hulu series is the way they portrayed Gloria Satterfield as being like the mother that Paw never had, and showing how much love she had for that family, and how well she took care of that family, and she was so selfless, and also the way that Maggie didn't really treat her right, and Maggie didn't even go to visit her in the hospital, and yeah. So you're right, Gloria Satterfield did slip on that loose brick maybe after Alec Murdaugh made her go and get all the suitcases out of the car that were really heavy, and she already had some physical limitations, and she's tromping up the front brick steps with all that heavy luggage, and then I don't even know if there really was a loose brick, but that's what Alec Murdaugh did to give his friend the case so that they could steal the money, right? That's what happened, and she really did love Paul, right? Her sons did get a settlement, except what happened was Alec Murdaugh stole the money, right? With his banker friend. I think they put it into some sort of a settlement, a structured settlement. And I don't know if they ever did get the money. I think they had to sue for it eventually. And I don't exactly know, but the reason that he had his friend, Alec Murdaugh, set those boys up with his friend to sue Alec Murdaugh is that he conceded liability to the insurance company, and the insurance company just paid, and then they did something with the money, and I think they stole it. But that's a story for another day. He stole all kinds of settlements, lots and lots and lots of them. All right. Now, finally, we're going to move on to the Kelsey Fitzsimmons brief, because if that's what you're here to see, you didn't miss a thing yet. You didn't see it, miss a thing. Oh, is Corri Hopkins here? Emily, I see you talking to Corri. Corri's going to be fine. She'll tell you that she's going to be fine. Nobody's trying to get her disbarred. I love the way that, I really hate the way that these rumors run rampant, and then they become a thing, and then people really believe them, and it's just not, it's not accurate. All right. But I also do have the motion for clarification that was filed by, I think it's Lally that actually signed it. In the Karen Reed case, we can look at that if we have time after we finish Kelsey's brief. Okay. Paul did love her dearly, says Tail Red, Texas. Toll Red, Texas. Maybe that's what it says. I'm not quite sure. All right, moving on. Turtle Boy said it last night. I know, and that's why I'm correcting it. Maybe it looked that way to him from what he was reading, and I don't know what he was reading, but I just want to correct the record to say that I do not think that they are trying to have her disbarred. I think that they are just trying to find some reason not to unseal the sidebars by saying Corri Hopkins is an attorney in another state. She's not really a pro se plaintiff, which makes no sense, because both things can be true. Hold on. Sometimes there's some hyperbole in there too, Aidan Carney is a satirist, and he can be hyperbolic, or maybe he just really didn't know. I'm here to tell you to calm down, okay? Because so many of you sent me frantic emails today that you were so worried about Corri that we need to start some kind of GoFundMe or something for her, but she's going to be fine. Okay. All right. Here we are. Here's the Commonwealth of Massachusetts, SJC, docket numbers and all. Kelsey Fitzsimmons against the Commonwealth. Kelsey Fitzsimmons in this case is the appellant. She is the one who is appealing, and so she's known as the appellant, but she's also the defendant in the underlying case, which is why it says appellant/defendant, versus the Commonwealth, who is the appellee. And this is the brief for appellant Kelsey Fitzsimmons, signed and dated today, November 10th, 2025, by defense counsel Timothy Bradel, the Silver Fox, and Martha Coakley, formerly the Attorney General. She's the Attorney General of Massachusetts, I think. Okay, and here, this is why appellate printing is so expensive. And you guys are like, why? Why is it so expensive? Here's why. Here's all the things you have to have. First of all, this has to be bound in like a nice color. Sometimes it's blue. I don't know what color they want. This might be the blue briefs, and then they have another color briefs. And so they have to be bound. And when I say bound, I don't mean like a spiral notebook bound. I mean like bound, like a real book binder kind of thing with, it's not a hardcover, but they're bound. And it's really expensive. And you got to have a lot of copies. And look, you have this whole table of contents. It has to be a certain font. It has to be a certain size font. It's got to be a certain type font, and it is very expensive. You have to have lots of copies, and appellate printing is a racket. Let's just say that. And then comes, after your table of contents, there is the table of authorities, which is all of the case law that you are citing in your briefs. Now, listen, something else that you need to understand. Appellate writing is a whole different skill set. It's a whole different skill set. If you are a trial lawyer, you likely do not write appellate briefs. You got guys for that. You hire people to do that. I have appellate counsel. I'm retired now, but when I was practicing for over 30 years, I had appellate counsel who specializes in only writing briefs. That's what they do. That's their wheelhouse. And that's why you hire experts to do the things. Everyone's got a skill set, right? Here's all the cases that are cited in the brief and on which pages they appear, and they are nicely alphabetized, as you can see. And then after the table of cases is the statutes on which you are relying in your briefs, because this is all questions of law. Appeals are about questions of law. Okay. Here are the statutes and the pages on which these statutes are going to be discussed. And then there are federal law / regulations and the authority. Here we have the Americans with Disabilities Act, with the citation to the U.S. Code, 42 U.S. Code, section 12131 to section 12. I see how detailed this needs to be. It's a very special skill set. Okay, moving on. This is where the meat of it starts. And here are the statement of issues. And there are, let's see how many issues, four issues that are coming up to the full panel of the Supreme Judicial Court, which is Massachusetts' highest court. Andrea Burkhart is an appellate attorney. Yes, Tina, yes, you win. Ding, ding, ding. That is what she does. She does it very, 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 very well. And it is a special skill set that not every lawyer does or feels comfortable doing or even wants to do. Okay. There are some lawyers who never want to see the inside of a courtroom. I would go absolutely batshit crazy if I had to sit in the library all day, drafting corporate contracts or something, mergers and acquisitions. That is something I would never, ever want to do. But there are some people become lawyers and they never, ever want to see the inside of a courtroom, and that's fine too. We need them all. We need them all. And I guess we won't have Kim Kardashian because apparently she failed the bar. Was that the first time she ever took the bar? Or has she taken the bar multiple times? Because I feel like she went to law school like 10 years ago, but I don't really know. I digress. All right, here we go. Here are the statements of the issues. Thank you to all the gifters that are coming out. Let me just thank some people real fast because I see a lot of memberships flying through here. Thank you, Gigi, for gifting 10 memberships. Gigi, you're amazing. And James just gifted another 5, and you are amazing too, sir. You're awesome. Oh, look at this. Friend of the dog gifted 10 memberships. A lot of memberships. You guys are awesome. And look who became a member. Corri Hopkins became a member. Thanks, Corri. Corri's my girl. And then James gifted another 5. Thank you, James. A lot of new members. Don't forget, new members, you have the special emojis for you. And Proctor got waffled, gifted a membership also. Thank you. Thank you so much. Appreciate you so much. All right, and we'll get back to the rest of the super chats when we come back. I'm glad that your withdrawal has been cured. Casey Paralegal. It is my pleasure. It is my pleasure. Okay, here we go. You didn't miss a thing because we're starting right now. Statement of the issues in the Kelsey Fitzsimmons appeal to the full panel of the entire 7-justice Supreme Judicial Court. Number one, whether this single justice applied the incorrect standard of review, where that court reviewed the Superior Court's pretrial detention order only for abuse of discretion, rather than conducting the required de novo review of the legality and propriety of the bail determination as mandated by Commonwealth v. Chisholm, Comesso v. Commonwealth, and Brannigan v. Commonwealth. And so we have discussed this before, but if you're new here, I will explain this to you again. It is defense's position that when they appealed initially to the one single judge, that judge was supposed to not just rule on whether Judge Kathleen McCarthy Nyman exceeded her authority in what she did. That judge was supposed to review the entire bail petition de novo or anew. Not just look at what McCarthy Nyman did, or Nyman, her name is Nyman, McCarthy Nyman did, and say whether or not that was appropriate or an abuse of discretion. That judge was supposed to look at it as if it was a brand new bail petition with a fresh set of eyes. And that justice did not do that in the defense's opinion. The second issue is whether under de novo review, the trial court erred in finding that the allegations constituted clear and convincing evidence that no condition of release could reasonably assure the safety of another person, where Ms. Fitzsimmons was a sworn North Andover police officer, cleared to work, had an insignificant record, was accused of one crime for which she could receive probation on a theoretical plea, had denied pointing a gun at an officer, is gravely injured and seriously debilitated from being shot at close range in the chest, and where the allegations are completely inconsistent with a risk of future harm. We've talked about this at length too. And it has been my opinion, my legal opinion, that there were less restrictive methods and bail conditions that could have been applied, such as urine testing. And as the defense is pointing out here, even if Kelsey took a plea right now, because the only thing that the grand jury returned a true bill on was an assault charge that carries a maximum 5-year prison sentence if convicted. But based on the fact that Kelsey was a police officer and she has no record, or she has, what did they say here? An insignificant record. She would just get probation. So are you really going to sit here and tell us that she's dangerous? She was shot close range in the chest, and where the allegations are completely inconsistent with a risk of future harm. Issue number 3, whether the Superior Court's revocation of release and order of pretrial detention violated the requirements of General Law 276-58A and B, where that court revoked the appellant's release and ordered detention without notice, without a request by the Commonwealth or probation, and without findings by clear and convincing evidence that no less restrictive alternatives could reasonably assure the safety of another person, ignoring the due process and substantive protections required under 58AB in case law. And I got a little ahead of myself because that's this issue, whether or not there are less restrictive means to assure the safety of other people. And the fact that they just threw her back in jail, or McCarthy Nyman did, without even considering anything else, and without the Commonwealth even asking that she be violated, and without probation saying that she was in violation, because probation said she's not in violation, I would not violate her. And the Commonwealth really had nothing to say at the hearing, because we listened to the audio of that hearing, and it was horrific. And I will never unhear Kelsey wailing at the end of it as McCarthy Nyman walked off the bench, turned off the Buckwheat, are you an asshole? Bye. Who, oh, that's the same person that comes in every time and just makes up we're all bipolar, especially you. You know, notice how many new accounts are like coming up and like attacking people. They have marching orders. Trust me when I tell you that they have marching orders of who to attack on what day. There is one specific account over there on the cesspool of Twitter who is absolutely obsessed with me. Obsessed. Like every day there's like 5 video clips of me and Turtle Boy. Me and Turtle Boy, we live rent free in this person's head. And you know who I'm talking about, and we know who's behind the account. So just wait. It's going to be so exciting when you find out. But they are completely obsessed. Obsessed. Like, I'm a lawyer with a microphone who's pretty loud on YouTube. I don't even play on Twitter. So when you're that obsessed with me, it's because you're really, really afraid of what I'm saying. And you're really, really afraid of what's going to happen to you and your friends very soon, because Proctor's phone dump is out there. It's going to implicate a lot of people, including the real murders of Officer John O'Keefe. So, you know, that's going to be real fun when that happens. But anyway, moving on. Issue number 4 says, whether the court violated the Americans with Disabilities Act by ignoring the federal mandate to provide reasonable accommodations to disabled individuals in a pretrial probationary setting where undisputed medical evidence demonstrated that the ordered scram breath testing device caused the appellant significant physical pain and difficulty in compliance, and where the court failed to consider routine available alternatives such as standard urine testing. Even probation testified at the hearing that he, when fitting Kelsey with the scram monitor, the breathe-in scram monitor device, noticed that she was in tremendous pain and did not believe that she was faking. Okay? Here's the statement of the case. For those of you who are new, there's going to be a whole summary of everything that's happened so far, so I don't have to give you the summary. It's going to be right here for you in the brief, because Bradle. Here we go. On June 30th of 2025, appellant North Andover police officer Kelsey Fitzsimmons was shot in the chest by a police colleague from just feet away after North Andover police appeared at her home to serve her with a restraining order. And then you are going to see these references to the record appendix. And the record appendix, that's another reason why appellate printing is so expensive, is because you have to have the entire record on appeal, which is every paper that's been filed so far. You know? Oh boy, they're really coming out tonight. These, you know what's so fun about these people is that they waited like a whole day. Because you have to be a member for 24 hours to chat, because, you know, like it's a privilege and not a right. And they waited a whole entire day. Thanks, guys. You guys are on it. You guys are on it. The mods are on it. It's just funny to watch these disgusting trolls come to life. It's not just buckwheat. There's another one in there too. All right, moving on. The order was just obtained by her fiance. So, my point was that the record appendix, the record on appeal, is also very expensive. And so it's a very, very thick record on appeal, and you have to pay for that printing also. The order was just obtained by her fiance ex parte from the Essex probate court, requiring Miss Fitzsimmons, completely without notice, to give him custody of her 4-month-old newborn baby, forfeit her firearms, and consequently forfeit her job, her upcoming wedding, and her relationship. Right. Everything. She saw everything flash before her eyes. And in that moment, she wanted to end it for herself, not for Noonan. The shooting occurred in her bedroom at 125 Phillips Brook Road in North Andover, Massachusetts. That house is currently in contract, and if not already sold. Kelsey had to sell her house too to pay her attorney's fees. So there's that. Ms. Fitzsimmons contends she obtained a firearm to engage in self-harm as a result of her entire future crumbling on the spot. She contends she would never point a gun at a fellow law enforcement officer, much less the officer who she considered to be a friend. The alleged victim officer contends appellant tried unsuccessfully to operate the firearm intending to shoot him, causing him to shoot her. There were no body cameras and no other witnesses to the events in the bedroom. On August 7th, I want to also point out to you that since June 30th, 2025, when Kelsey was forced to hand her baby over, her 4-month-old son, over to those officers, her colleagues, her fellow brothers in blue, she has not seen her baby since June 30th of 2025, and she was breastfeeding. And if that doesn't anger you, I don't know, maybe nothing will. On August 7th, 2025, after 38 days in Massachusetts General Hospital, appellant was arrested, handcuffed, and shackled to her hospital bed. Ms. Fitzsimmons was arraigned on the 3 foregoing charges out of Lawrence District Court from her hospital bed via phone on August 9th, 2025, and held pursuant to 276-58A. Judge Frazier, following a written motion by the Commonwealth. The charges were presented to the Essex County Grand Jury on August 25th, 2025, where the grand jurors returned a true bill on only 1 count of assault by means of a dangerous weapon. Okay. She was not indicted for the attempted murder charge that they wanted. That was the top charge that they wanted to charge her with. Attempted murder. They didn't get that. They got 1 assault charge with a deadly weapon. Oh, Angela, welcome. It's your first live. Don't read the chat because there's some vile people in there, but the mods look at them quick. But welcome, Angela. Welcome. There we go. That's what has them so irate. I know. Tell us what else, buckwheat. I'm not that buckwheat. The other person that just got kicked out, well, I'm not even going to say because you might have your kids in the room and stuff. I can't tell you what they said, but it's kind of funny. It was kind of funny, but disgusting. And kind of funny. All right, moving on. Appellant was arraigned in Essex Superior Court, Salem, for the single indictment on August 28th of 2025. Despite the drastic reduction in the charge and the eligibility for probation, the Superior Court, again, McCarthy Nyman judge, held Ms. Fitzsimmons pursuant to 276-58A after a motion filed by the Commonwealth. On September 8th of 2025, after filing several motions, and where you see how it says RA, volume 1, 45 to 50, that is a citation to the Record on Appeal, volume 1, pages 45 to 50. So if the judge wants to look at what they're referencing here, that's where they would go to find those papers. When Olivia does motions in Turtle Boy's case, everything is hyperlinked, but appellate court is very, very strict. And this is the way you need to do it in appellate court. Just in case you're confused. Appellant was released on maximal conditions, including GPS bracelet, reside at mother and stepfather's residence, no possession of firearms or dangerous weapons, no alcohol, scram alcohol breath test device, 24/7 house arrest with 48 hours notice to probation for attorney medical appointments, no contact with witnesses, and no contact with her infant son, regardless of future rulings on the subject made in the pending probate and family court action. On September 10th of 2025, appellant filed an emergency motion for immediate relief from the scram order. Hang on for 1 second because I missed this footnote. Footnote 1 was up here, which I missed at the top of page 7. It says that the grand jurors returned a true bill on only 1 count of assault by means of a dangerous weapon. Footnote 1 reads, the Massachusetts sentencing guidelines provide for a probationary sentence in Ms. Fitzsimmons' circumstances in the little or no record category for the 1 count in this case for this maximum 5-year felony with concurrent district court jurisdiction. Unless the court acts here, she will have to endure pretrial incarceration on a case where, if she pleads guilty, which she will not do, she would almost inevitably get probation. This sole charge does not warrant detention or any 58A finding. 58A is the dangerousness statute. What does this remind you of? I'm having sudden flashbacks of, if she pleads, it'll be over. If not, it's going to be a whole other episode. Right? That's what it reminds me of. Get her to plea. On September 10th, 2025, appellant filed an emergency motion for immediate relief from the scram order. Ms. Fitzsimmons filed an affidavit with her emergency motion outlining for the court that, quote, I am required to blow into a scram device 3 times a day. Each time I attempt to use the scram device, it takes a minimum of 4 to 5 times of blowing due to the amount of breath the device requires to register. Each time I blow into the device, it causes me extreme pain due to my broken ribs and the fact that my lung is not completely healed from being shot. I have also developed significant anxiety that my inability to blow into and complete each test will trigger a warrant for my arrest. I feel that putting my body through the exertion that this test requires is causing major setback to any healing progress that I have made. This is just a side note, but the fact that she is still healing from being shot in the chest, at point blank range, right? Still has fragments of the bullet in her body, fractured ribs, collapsed lung requiring insertion of a chest tube, lacerated liver. She had 5 surgeries while she was in the hospital. She had to put off her 6th surgery because the judge wouldn't allow her to have the ankle monitor on after the surgery was completed. The fact that she is still healing and that she's in a jail in Chicopee, which is full of germs, by the way. I'm hoping that she's not getting worse instead of better, and that's horrific. So Kelsey's affidavit that she filled out was only talking about blowing into the scram device, because remember, they sent her home, or the judge let her go home for 48 hours before they came back in and said, listen, is there something that Kelsey could do to test for alcohol that wouldn't be so painful for her, because it's cruel and inhuman, judge. And that's when the switch flipped on Judge Kathleen McCarthy Nyman. The switch flipped. Oh, well, I don't want to cause her any pain, so I'm just going to send her back to jail. I don't want to torture her. I'm going to send her back to jail. It was outrageous. Oh, wow. There's Jeff Fitzpatrick. And he wants to know why I'm such a bitch. Is it menopause? Where are these people coming from? They're in droves tonight. Defamation will get you timed out. Chill, children, says Team Brittany. And that's not even talking about, you're not even talking about me. You're talking about defaming other people. People are vile. Yeah, you know what? I think that I was gone for a couple of days because I was actually on my vacation, and they were like, oh, let me quick sub up so that when she comes back, I can get right into the chat and like say ridiculous, stupid things to her. Yeah, leftovers from the full moon. Oh, Kazi G. Did I say that you were starting a YouTube channel? They're super triggered lately. I know, because they're all going to jail telling me I need to get laid. As if you know my schedule. Oh my God. Oh my God. You're so disgusting. It's all right. It's all right. We'll see. That's all I'm going to say. We'll see. Appellant's mother also provided an affidavit to the court stating, I witnessed her struggling extremely with blowing into this device. There was one occasion where she almost passed out. After that occasion, she became very shaken and sick for most of the day. The parties appeared. I'm not giving you any more material. You can try to set me off and try to get me to have a tantrum and try to get me to curse you out. It's not going to work. I know you're desperate for content, and I know you really, really, really want to clip me saying the F word and other curses because you really have nothing better to do except repurpose my content to use as your content, trolls. But You're going to have to do better. We are in the We Do Not Care Club. Thank you, Padlin Loon. It's the We Do Not Care Club. We do not care. We do not care if you think that I'm in menopause. We do not care if you think that I look like the Crypt Keeper. We do not care if you think that I need to get laid. We do not care if you think that I am ugly, fat, old. What? We do not care. We do not care. We do not care, because that is more a reflection of you and who you are, not who I am. I'm very comfortable with myself. You, on the other hand, I mean, maybe it is. We do not care. The parties appeared before the court. McCarthy and Nyman the next day. An appellant requested alternatives for scram testing. Footnote number 2. Ms. Fitzsimmons respectfully submits that it is important for this court to listen to the recording of the trial court bail hearing, which recording was submitted to the SJC on a thumb drive with the 221 memorandum. The single justice apparently only reviewed the transcripts later provided by the Commonwealth and was not able to appreciate the actual treatment of the defense and the probation department, which made it clear by listening to the hearing, culminating in the judge departing the bench while defense counsel was mid-argument. Right. We heard them slam the stop button down on the old-fashioned tape recorder that it seems that they probably used to tape record it. What should have happened could have taken 5 minutes, where the defense reported the difficulties and had an alternative method of alcohol testing put in place. Instead, a completely improper nightmare scenario played out. Rather than utilizing a readily available common alternative method of alcohol testing, the court surrendered the appellant back to jail without a request to do so from either the Commonwealth or probation, in violation of General Law 276, Section 58B. Right. She was not in violation of her conditions. And so therefore, what the judge did was wrong on the law. On the law. The court shut down the probation officer, cut off counsel, and walked off the bench while undersigned was arguing for his client. In writing, she accused the defense of manipulating the situation and repeatedly misstated the record. She did, because we read it and we listened to it. Just hours after the court's unexpected revocation order, undersigned filed on the same day a motion to reconsider and attached emails from probation to confirm alternative testing. That's right. We read that too. On September 15th of 2025, appellant filed a supplemental exhibit for her pending reconsideration motion that included a very difficult to obtain letter from her trauma surgeon corroborating the prospect of Ms. Fitzsimmons' claims of pain while breathing deeply into the scram device. Do you know why it's so hard? Do you know why it's so hard to get an affidavit or a letter from a trauma surgeon? Because they're doing surgery all the time. That's why. And I remember when there were people in the comments and in the chat saying, oh, well, Tim Brader was unprepared. He was unprepared. He should have had a letter from the surgeon. No, listen, let me just tell you. In any other court, even in Massachusetts, any other judge would have taken judicial notice of the fact that KELSEY FITZSIMMONS was shot in the chest by a fellow officer. You know, that's a side note. And that she spent 53 days in the hospital and she had 5 surgeries and she still had bullet fracture. Any other judge in any other, even in Massachusetts, would have taken judicial notice of that fact. And any other judge in Massachusetts would have known that there are other ways to test for alcohol besides having a woman who was shot in the chest breathe into a tube. Not this judge. Not this judge. Nonetheless, so when people said that Tim Bradel was not prepared, I completely disagree. Okay. Everyone knows where she was. She was arraigned in her hospital bed while she was handcuffed to the hospital bed. So we know surgeons are busy and they don't like writing letters. That's right, Aaron. That's right. You are supposed to bring your common sense into the courtroom with you. Well, what I say is don't leave your common sense at the door if you're on the jury. But a judge is held even to a higher standard, right? If you're a judge in Massachusetts, you should know what other methods for alcohol testing are available to the court, right? It's not rocket science when you do it every single day. Moving on. Nonetheless, on September 16th, 2025, the court issued an order denying defendant's motion to reconsider. imposition of custody, and for reinstatement of original terms of release with order for alternative testing. Ms. Fitzsimmons filed an emergency petition for relief from order revoking terms of release brought pursuant to General Law 211, sub 3, to the single justice of the Massachusetts Supreme Judicial Court. The single justice, and this is Judge Dewar, or Dewar, D-E-W-A-R. Isn't that like a Scotch? Dewars. I'm just going to say Dewar. Hold on. The single justice, Judge Dewar, denied the petition without a hearing. Ms. Fitzsimmons now petitions the full court for relief pursuant to SJC Rule 221, which I believe we looked at on another stream, and that does give them the right to appeal this to the full panel. And then the full panel had to agree to hear it, and we read the order in which the full panel did agree to hear it. So they could have rejected it, but they didn't. They agreed to hear it because I think they know how important this is. Okay, this is a constitutional issue. And time is of the essence here because every day that goes by, Kelsey is in more danger in jail as a former corrections officer and police officer. She is losing out on bonding with her infant. And there are a lot of constitutional violations here, in my opinion. And that is why the briefing schedule is so tight. Bradle's briefs were due today, and the Commonwealth briefs will be due on the 20th of November. And after that, if they want oral argument, they will then schedule the oral argument. They have the right to not hear oral argument. They might just decide on the papers. Here's the statement of facts. Wait, didn't we just read the statement of facts? Well, there's more facts. Statement of the case. Now this is the statement of the facts. On June 30th, 2025, Ms. Kelsey Fitzsimmons was the mother of a 4-month-old infant and a police officer in the North Andover Police Department. She has been a law enforcement officer for approximately 5 years, first as a corrections officer with the Essex County Sheriff's Department, and then as a police officer with the North Andover Police Department. On the day in question, she was on maternity leave in recovery from a postpartum depression diagnosis and had been cleared in a fit for duty report. She was scheduled to return to work on July 4th of 2025. That day, her fiance and baby's father, it's on June 30th, told her to meet him at the local park and instead stood her and the baby up and got an ex parte restraining order with an affidavit full of shocking lies. Footnote 3, which reads, in no free society should a person be able to go to a court, fill out a form, and send the police to a new mother's home and take a baby away from her without any opportunity to be heard. If there are allegations of imminent bodily harm, that is a matter for police and 911, not the court system, listening to one side of an issue from a private party with their own agenda and ulterior motives, seeking a leg up on future custody matters. Praise be. Under her eye. Kelsey went home and 3 male North Andover colleague police officers came to the house, serving the order, taking the baby, her future marriage, and her career with them all at once in the space of minutes, without her ever being heard or able to defend herself. She never pointed a gun at any officer. Unfortunately, the department's decision to avoid body cameras leaves the case as a he said, she said exercise and seriously hinders the strength of the Commonwealth's case, a highly relevant factor in the bail determination. While inside the residence, Ms. Fitzsimmons began gathering clothes and supplies for the baby. During this time, appellant's mother and the infant's father arrived at the home, because that was a really good idea for them to call Justin, a lay-in, to come down and take the baby. like that. If she already didn't have postpartum depression or psychosis, don't you think that would have thrown her into a tizzy? Oh, knock, knock, knock. Hey, Kels. Hey, Kels. Hey. Yeah. Hey, how you doing? Yeah, we know you're supposed to come back to work in 4 days, but I got this piece of paper for you. The Justin has a restraining order against you. Oh, and here's another piece of paper. We're going to take the baby. We need to take your baby away. So just give us your baby. Like, are you kidding me? Would that throw anybody off the edge? Ms. Fitzsimmons remained upstairs with Officer Noonan, while Officer Houston and Lieutenant Daly were on the first floor with appellant's mother and Mr. Alayan. It's a little confusing where Justin was, whether he was in the garage or the basement, because he said he heard gunshots at some point. Was his sister with him too? And her mother was there too. Yes, her mother was there. I think we read that in some recent documents. With only Ms. Fitzsimmons and Officer Noonan on the second floor of the home, Officer Noonan stated that Ms. Fitzsimmons, kneeling on the floor of her bedroom, lunged behind a door. Footnote 4. It is notable that there is no door to or in Ms. Fitzsimmons' bedroom. I'm going to say that a little bit louder for people in the back. Officer Noonan, in his statements, has said, and we've read it in several places, that Kelsey was packing up for the baby, lunged behind the bedroom door, and reappeared pointing a firearm at him. There is no door to or even in Kelsey's bedroom. It is an open floor plan. We looked at the Zillow listing. Where was DCS? They didn't come. DCS, nope. Did they have a mental health professional with them when they came to serve these things? No, they didn't. Noonan, the new proctor, says seriously. We saw the picture. Yeah, we looked it up. We saw it on Zillow. We knew there was no bedroom door. So, Officer Noonan, were you lying then or are you lying now? Officer Noonan, you said that she lunged behind the bedroom door. Where exactly was this bedroom door? Oh, the door to the bedroom? Oh, yeah, you're lying. Why? Why would he lie? I don't know. Because if he used excessive force, that could get him suspended, right? Nobody was even, right, big old dog. DCF and mental health professionals were never even consulted. Nothing. There is no door. Hypothetically, if he'd lie about a door, what else would he lie about? Hold on. No, her mother was there. Her mother was there. That is true. These are the defendant's papers, so it is true that her mother was there. Kelsey Fitzsimmons adamantly denies ever pointing a firearm at another person. Ms. Fitzsimmons was ultimately shot in the chest and med-flighted to Massachusetts General Hospital, where she underwent multiple procedures, including chest tube placement, percutaneous drainage of a hepatic collection, and ERCP with biliary stent placement due to injuries sustained from the gunshot wound to the chest. Footnote 5, which says, gunshot wound to the right hemothorax with retained bullet fragments in the right upper back. Moderate right hemothorax requiring chest tube placement. Right middle and lower lobe pulmonary contusions with active bleeding. Grade 4 hepatic trauma with active bleeding from the right hepatic lobe. Comminuted right posterior 12th rib fracture. Right anterior 11th rib fracture at the costochondral junction. Rib fractures are very painful. They take a long time to heal. There's really nothing that you can do for a rib fracture except not breathe so deeply, rest. You can't cast it. There's no reason to do surgery on these rib fractures. You can't, there's nothing you can do. Ask anyone in the chat who's ever had a rib fracture. And then couple the rib fracture with a collapsed lung requiring a chest tube. And guess how long that takes to heal? A very long time. A lot longer than 53 days. She's lucky to have survived, Jean Marie RN says, and she knows it because she's a nurse. Hepatic is liver. That's correct. She had a lacerated liver as well. These are very painful injuries. Yeah, you could wrap up your ribs. Good luck, right, Scott? Right? You know. She's lucky she survived all those injuries, says Inverted Sneaker. Keeping It Real says, it's a he said, she said incident, but yet you believe the cop that shot the innocent female officer and friend of said officer. What are you talking about? I don't know who you're talking about. The cop that shot the innocent female. Are you talking to me or are you talking to somebody else in the chat? That's right, KDB. Ribs fractures can only heal on their own, in their own time. Tom says it hurts every time you breathe in and exhale. And Amy says the liver injury is what I'm shocked she survived. Zoe says she could have been holding an infant nose suction bulb. She could have been holding part of a breast pump. There's lots of items she could have been holding when she popped out from behind an imaginary door. But she does admit that she was holding a gun. So I don't think there's any question about that. Okay, moving on. While in the hospital, Ms. Fitzsimmons consistently engaged with health supports, including behavioral health. Upon discharge, she was cleared of any mental health concerns by her MGH psychiatrist and her consulting psychologist, Dr. Paul Zeisel. Why is that name familiar? We saw Dr. Paul Zeisel in another case. He may be the consulting psychologist in Lindsay Clancy's case. You can correct me if I'm wrong, if anybody knows. Like countless new mothers, she had suffered from a transient bout of postpartum depression. Since discharge, Ms. Fitzsimmons has undergone an extensive risk assessment by Gina Tinney, LICW, a private contractor and CPCS vendor with a Master of Social Work, summa cum laude, from Edinburgh University. Ms. Tinney corroborates the findings of the two clinicians and adds her third expert voice that Ms. Fitzsimmons is not dangerous. She reported that Ms. Fitzsimmons is classified as a low risk of violent recidivism, absent of intensive services. Low risk categorization would mean that the person is apt to abstain from violent conduct on their own, while high risk means individuals are unlikely to desist from crime unless they receive intensive services. Additionally, Ms. Fitzsimmons scored exceptionally high for protective factors across all evaluated domains, which gives further credence to the low risk categorization. While she has a recent history of postpartum depression and post-traumatic stress disorder, she has demonstrated a sustained recovery and exhibits high levels of coping, emotional regulation, and treatment engagement. Her social supports, living circumstances, and structured routines further reinforce her stability. These protective factors significantly mitigate static, unchanging risk factors and suggest that any residual risk is manageable within the community in her established supportive environment. Since the court's wholesale denials of the defense filings, Ms. Fitzsimmons has been held at the Western Massachusetts Women's Correctional Facility in Chicopee, Mass., where she has been in solitary confinement due to her status as a police officer and former corrections officer. Since being incarcerated, Ms. Fitzsimmons has been threatened by a male inmate when he, quote, found out something about that bitch. Footnote 6. Which reads, the court ignored the increased risks inherent in incarcerating a police officer and former corrections officer. The defense learned on September 28th, 2025, that Ms. Fitzsimmons has in fact been targeted at the Chicopee Women's Correctional Center when at 9:15 a.m. on September 24th, 2025, a biological man identifying as a female threatened petitioner, saying in her presence, quote, "I found out something about that bitch," end quote, and later directly to Ms. Fitzsimmons, quote, "While walking to his cell, he began pointing and screaming at inmate Fitzsimmons, who was currently on the rec deck, and stated, quote, 'You PC bitch, you best check out who you're effing with,' end quote." See Hamden Sheriff Department incident report. We did read that. We had the police report and we read it together. The fact is that petitioner will continue to be targeted due to her profession and is at enhanced risk of harm 24 hours a day. There is no legal basis to hold her in prison as a pretrial detainee, especially given her law enforcement history. She is under enhanced risk of harm and even death and should be released forthwith. Before we go to the summary of argument, let us go to the chat for a moment. Thank you, little old lady, for being a member for 12 whole months. Happy anniversary to us on top. Thank you for your super sticker. Sassy Desk Diaries, thank you for your super sticker. Also, and Kay Willis is here. Says, welcome back. Hope you had a great time. Thank you for being here for 12 months. Happy anniversary to us, Kay. And Sassy Desk Diaries, thanks for becoming a member. And Letter Rose by Better has been here for 22 months. An OG cupcake, nowhere I'd rather be. Well, there's nowhere that I'd rather have you be either. So there's that. Great minds, right? Thanks, Betsy, for your 10. Says, sweet baby Jesus, I missed you. Love you with all of my heart. Thanks, Betsy. I love you more. Venus Blue, Crash Batty, has been here for 7 months and says, love from Florida. I'm so happy you're live. It finally got cold enough to wear my Cancun hoodie. It's going to be in the 30s tonight. That's awesome. I'm so glad that you like it. And I'm so glad that you're wearing it. Represent. GDT is here. Hey, girl. For 19 months, Zoe's Extraordinary Playlist reminds me of you. Oh, thank you. It's a compliment. I like that movie. Laura Riker said it would take a lot of sage, then maybe LOL. I usually have my sage right here because, it's really, we need it. We do need it tonight. I mean, the full moon was awesome. Were you guys out for the full moon? What night was that? Wednesday or Thursday? It was amazing. It was amazing. I saw it on a beach somewhere. The most blessed Gigi on earth says, woods equals snakes. No thanks. Enough snakes walking around. Thank you, Gigi, for your 5. And Brigitte says, Melanie, Norfolk County is going after Hopkins' lawyer's license. No, I want to clear that up. And your next super chat said, thanks for clearing that up. Yep. Not true. Not true. Thank you. I'm glad that I was able to solve that or correct that rumor for you. The Goodmans are here and they gifted 5 memberships. Thanks, you guys are awesome. And keeping it real, has been here for 11 months and says, it's sad to be a resident of Massachusetts. I know a lot of people feel that way. A lot of people feel that way. You're not the only one. Galaxy Girl says, it's crazy. The judge didn't even know how often she was getting scram tested. She could have changed it to once a day instead of 3 times to accommodate. She could have. She didn't want to. She wanted it to be random. And then she got mad when she found out it wasn't random. Remember? And then it was brought to her attention that it could be random if she was allowed to go to a facility and pee in a cup. That could be totally random. And the judge would have been happy with that. But no, the judge said, oh, I don't want to torture you. So back to jail you go. Off to jail you go. Oh, please. Thank you, Galaxy Girl, for your 5. Darth Tater's mom says, Mel, D.A. always said, don't piss off an Irish gal. She will never let it go. Feel bad for the haters. They have no clue what you will do. Like, you're so right. You're so right. You're so right. Desperate people do desperate things, I find. And so I just find it so amusing. I mean, you said it. You said it very well. I don't need to say it better. Thank you for your 20. Criminally Curious Cupcake says the trolls are out in force because they know they're going to jail when the walls come down. I know. And anytime they come for me, because really, who am I except like a background character in this scenario? Anytime they come for me, they're trying to distract from like what's really over here, Like, oh, look over here, because we don't want you to see what's over here. Proctor's text messages are over here. They're going to implicate a lot of people. And what I'm going to talk about after this is a reason, something that may be the root of the entire problem. There's a little Easter egg to keep you going until later, because I think I might have an idea of what's at the root of this whole thing, the root cause of this whole Proctor thing. And why would Proctor give up everything? What other investigations has Proctor been involved in wherein his investigation cleared a whole lot of Boston PD officers? Oh, yeah. Maybe that's the root of it. If you know, you know, root cause analysis. They've been waiting for me to come back. They subscribed when they knew that I was busy, so that they could come in, right? Indigo Forever, OCOV. Yes, 100%. I didn't know until the other day. Kelsey is here, says Court. Hi, Court. Hi, Kelsey. Everyone say hi to Kelsey. Purple hearts for Kelsey. We love you. Yep. We'll talk about that after this. I don't want to digress too much. Thank you, Criminally Curious Cupcake, because that is exactly 100% the truth. Hi, Romy. I miss you. I love you. I haven't seen your name in a long time, but you've been here for 10 months. And so she says, thanks for going over this. You're welcome. Pimabo became a new member. Welcome. Behind Blue Eyes says, trolls, there are many cockroaches out there to bond with. You will not find them here. Move on. Move on. Yeah. Look around and find out. It's all right. Thanks for your 5. Trolls, don't be jealous. She is prettier than you, says Nurse Jones too. Oh, you're sweet. Thank you. But, you know, it's all these filters on StreamYard. By the way, this isn't TikTok. StreamYard doesn't have filters. So, I mean, there's that. But whatever makes you feel better about yourself and helps you sleep at night, you go on with your bad selves. Come on with your bad selves. Thank you, Nurse Jones, for being here for 18 months, in Virginia for 19 months. You're the best. My favorite by far. You're the best. And Darth Tater's mom with another 10 throws and says, my dad always said, oh, I know. I'm like, my DA says that? Your dad's a very smart man. Your dad's a very smart man. Thank you for your dad. All right. Stay strong, Kelsey. Everyone's here for you. We're here for you. It is. We are the We Do Not Care Club. All right. If you see this on your screen, it is my cursor. It is not a fly. Please do not smash your television and send me a bill. Hold on, please. One moment. Summary of argument. The trial court's actions are indefensible in the circumstances at bar. The decisions about the concept of dangerousness and, if allowed to stand, will seriously dilute the high standard previously solidified in case law. Even if dangerousness is proven, incarceration is the last resort, especially for a police officer and former corrections officer, and only then by clear and convincing evidence. These constitutional and case-based guarantees are not mere optional formalities. Here, such a finding is chilling, heartless, and legally baseless. The trial court discounted so much to get the case to where it is. KELSEY FITZSIMMONS is a sworn law enforcement officer from 2 different Essex County agencies. Far from posing a danger, she has passed the many hurdles to becoming an officer, sworn an oath, and has been entrusted by the community to protect them from danger. She has an insignificant record from 2018 that had no effect on securing her law enforcement career, and a clean record in Essex County law enforcement. Her service as a public safety official, proudly protecting those in her town and in her county from danger, putting herself in harm's way, was all but ignored by the trial court and is strong evidence in her favor. The nature of the incident is also inconsistent with the requirement that there be clear and convincing evidence of some ongoing risk of future danger. On the Commonwealth allegations, Ms. FitzSimmons assaulted the officer with a gun in the course of attempting self-harm due to a complete collapse of everything important to her at the moment. At best, On the Commonwealth's allegations, the officer was placed in apprehension in the course of events that had nothing to do with him personally. There is no animus or motive to harm him going forward. In fact, the record points in the complete opposite direction. Ms. Fitzsimmons publicly stated that that officer was not just a colleague, he was my friend. That officer and I experienced a very difficult and sad call for service together last summer. That call for service that day was a true tragedy and caused this officer and I to build a friendship due to experiencing it together. To this day, his support during that hard time is something I am still grateful for, regardless of this recent incident that occurred. There is no likelihood that Ms. Fitzsimmons, stripped of her firearms, a bit over 5 feet tall and 110 pounds, who can barely take a deep breath, would put the SWAT-trained armed officer or anyone else in danger going forward. She is gravely injured and presently scheduled for her 5th operation at MGH. I thought it was her 6th, but I think I lost count. She should benefit from reasonable accommodations under the Americans with Disabilities Act rather than be housed in a prison cell. Alcohol was an irrational focus of the trial court. There is no likelihood that alcohol consumption is a real factor here. The incident had nothing whatsoever to do with alcohol. Drinking the weekend before at her bachelorette party is hardly a bellwether of ongoing alcohol abuse by a new mother and full-time sworn police officer, right, who's also breastfeeding. Her serious ongoing medical struggles all but rule out alcohol abuse and manifestly do not require an unyielding approach to alcohol testing. She should not be required to satisfy phantom concerns, and if the court for some reason deems such testing necessary, she can easily drive 10 minutes down the road for urine testing rather than be tortured with a constantly recurring breath test. This is a good time to break from the document and point out to you that another case that we followed very closely in Massachusetts, the Karen Reed case, Karen Reed was charged with murder involving alcohol. And Karen Reed did not spend any time in jail. She was bailed out. She was bonded out immediately, both times, maybe overnight until she got arraigned or was arraigned in both both in February and then again in, I think, June or July. Never had any alcohol monitoring during the course of her time awaiting trial. None. The foregoing factors strongly militate. The foregoing factors strongly militate against a dangerousness finding and certainly against incarceration. Her demonstrated commitment to public safety in the community should itself negate dangerousness in a one-count case that barely makes grounds for dangerousness and qualifies for a probationary sentence. Ms. Fitzsimmons is a lifelong North Shore resident with indelible roots in the community from her upbringing, family, friends, job, and education. She has a devoted family and a now 9-month-old baby whom she earnestly wishes to raise, cherish, support, and continue to assist in caretaking. She has everything to gain by staying with her family and fighting these abominable charges and clearing her name. It is clear that Ms. Fitzsimmons is well within the Commonwealth's presumptive personal recognizance framework. The lower court should be reversed in favor of personal recognizance and certainly, at the very minimum, not result in Ms. Fitzsimmons' incarceration. Oh, and there she is. Here's a picture of Kelsey in a police car. Come to your screen if you can do so safely. Oh, Kels, look, I have the same cup. We're twins. Just got that in a cup holder. Hold. Argument. Supreme Judicial Court jurisdiction. The proper means for review of a legally and factually erroneous trial court bail revocation and a single justice error of law is through the instant appeal to the full bench, invoking the court's inherent authority to correct errors and abuses in inferior courts as codified in General Law 211, Section 3. citing some case law in which 2 leading bail revocation cases where the full SJC bench accepted appeals from the single justice and heard the cases on the merits without questioning single justice jurisdiction. In Comesso v. Commonwealth, the SJC upheld the jurisdiction of the single justice to review bail determinations under Section 58. The court stated, we therefore uphold the jurisdiction of the single justice to review bail determinations under Section 58. Similarly, we think that the full court has jurisdiction to review on exceptions, report, or appeal questions of law arising in a bail determination by a single justice under Section 58, General Law 211, Sections 5, 6, etc. In addition to confirming such jurisdiction in the single justice session and the full court for questions of law, the Comesso bench allowed de novo review of a bail determination in the single justice session. The statute is not explicit as to the role of the single justice. Relief in this type of case must be speedy if it is to be effective. Right. That's the whole point. It has to be speedy because if a person is incarcerated unlawfully, you need to get them out of there, but quick. Time is of the essence. Bail determinations must often be done in haste without that full inquiry and consideration which the matter deserves. We therefore think that the single justice has the power to consider the matter anew, taking into account facts newly presented, and to exercise his own judgment and discretion without remanding the matter for reconsideration by the superior court judge. Okay, so what Tim Bradel is arguing here is that, look, you can decide on this. You don't need to send this back to McCarthy-Nyman, which is usually what happens in an appeal. Usually the appellate court will send it back to the trial court for further proceedings, like a new trial, like hearing a motion again or hearing an issue again, like having another hearing. But in this case, Bradel is saying, you don't need to do that. You can decide this on your own without sending it back to that trial judge because we've seen that film before and we didn't like the ending, basically. It is axiomatic that bail decisions must be speedy if they are to be effective. Footnote 7, which is cites a case, Stack v. Boyle. The bail review framework etched into common law by this court in Comesso, Chisholm, Brannigan, Infra, and their progeny mandate review and a de novo decision. The full court's review of a decision incarcerating a defendant while awaiting trial will be focused on whether the detention decision was truly rendered only in carefully circumscribed circumstances and subject to quite demanding procedures. Errors of law in connection with review will be remedied by this court's own independent determination of the law and its application to the case at hand without deference to a lower court. Whereas here there are errors of law found in the single justice determination, this court should also decide the bail issue, confirming and following the principles of Comesso, Chisholm, Brannigan, and Stack, and decide the issue without further deference or delay. The erroneous intrusion on appellant's liberty interest cannot be restored at a later date through the appeal of a final adverse judgment or by any other available means, and should be remedied expeditiously by this court. Right. Not to mention, and I don't know if they're going to mention this because this is a cold read for me, every month, every day that she is missing with her baby, she is missing all of the milestones. She has missed 4.5 months of her infant's life. Next section, the trial court's order must be reversed. In supporting its decision, the court resorted to attacking the attorneys on alleged procedural deficiencies and manipulation in its written rulings on the events of September 11th, and in denying the reconsideration and ignoring the medical evidence it claimed was initially missing. The court apparently forgot that at a prior hearing, the court suggested and the defense agreed that the facts in the prior filings would be incorporated by reference. So all facts could be before the court. In its ruling, the court apparently ignored this position, claiming a lack of medical evidence and a lack of specifics on simple urine testing that is ordered and or referenced in court likely every single day, and undoubtedly utilized by this very court over her several years of experience. I feel heard right now. I feel heard. I was screaming this. We were all screaming this. I screamed this at the beginning of this stream. The record appendix contains everything filed for the trial court's consideration and was, as far as undersigned counsel understood and expected, incorporated into the judge's state of knowledge on the bail determination as a whole. Right. But note 8. This is accepting 2 exhibits generated after the court's denials, the risk assessment prepared by, I don't know how to pronounce that name, Jeanna, Jeanna, Gianna Tinney, LCSW, and the Hampden County Sheriff Department incident report, both generated after the trial court decisions. Nonetheless, these can be considered as part of this court's de novo determination. Okay, good. I thought I was losing my mind for a second because I didn't recall that assessment, the risk assessment report by Gianna Tinney, and that is because it is new. But according to the case law, the SJC is allowed to consider new evidence in their ruling. The court's focus on the state of the record was unexpected and inconsistent with the history of the proceedings. During the September 11th hearing for a motion for relief, the court incorrectly stated that it had no medical support, whereas defense counsel had submitted a medical notice to the court prior to petitioner's initial release on September 8th, 2025. The medical notice laid out various issues Ms. Fitzsimmons was suffering with, including difficulty breathing, broken ribs, and other items provided, which was impounded at defense request. Further, Ms. Fitzsimmons being shot in the chest is laid out in the initial charging documents filed, and certainly no secret in the matter. The court was aware as early as the second hearing on September 8th that Ms. Fitzsimmons had difficulty breathing due to her healed punctured lung and broken ribs. In response to the court's revocation, claiming a deficiency in the medical documentation, defense counsel further provided the court with a letter from Ms. Fitzsimmons' trauma surgeon, removing any issue whatsoever, where he corroborated petitioner's medical notice and affidavit, her mother, and the ACPO, the Assistant Chief Probation Officer, I think, and opined, quote, "In my medical opinion, a fracture of the 12th rib can cause pain that may persist for several months after the injury. The severity and duration of pain following such a fracture vary, and it is difficult to predict how long symptoms will continue in any given patient. Additionally, retained bullet fragments can also cause chronic pain that can be exacerbated by movement, such as deep breathing." The court ignored what it demanded in its denial of the reconsideration motion. The court also ignored the second to last sentence of Section 58A2, which provides, quote, "The judicial officer may at any time amend the order to impose additional or different conditions of release." So the judge had the authority to do that. Further, the court erred in citing 58A4 as the applicable circumstance and found noncompliance. However, this was not a reopening of a 58A. This was a revocation under 58B, which clearly, as set forth herein, did not conform to the requirements for such action. Further, the court misstated the record, alleging that defense counsel did not provide alternatives to scram breathing. Urine testing is a common tool used by the trial court every day and not a complicated or obscure request by petitioner. Counsel did, in fact, reference testing alternatives at several times during the September 11th scram hearing. And here's all the time, the record, all the places in the record by page and line number. Unfortunately, the court's demeanor severely curtailed any elaboration from probation or counsel, culminating in the court preventing any further discussion by walking off the bench mid-argument of undersigned. The defense requested alternative testing, which was readily available, and reserved specifics for the time being to avoid further enraging the court. And the court, leaving mid-argument, prevented the remainder of the information coming out. 100%. 100%. We were there. We heard it. We were horrified. We still are horrified. Our outrage continues. And we have an emoji for that, which now is completely appropriate here. It is the "We Are Outraged" emoji. It was invented during the Karen Read trial, but it certainly applies here. In addition to "Wait for Us." She was rude as being very nice, Rachel. That is a very nice way of putting it. Because sometimes we also feel like we're in the Twilight Zone, right? Don't we feel like we're in the Twilight Zone so much of the time, which is why we have a Twilight Zone emoji. And sometimes it is like we are in the land of the lost, and that's when we put Chaka up in the corner. Because if you are, I don't know, what are we? If you're Gen X, you remember the 1970s TV show, Land of the Lost, and Chaka was from the Land of the Lost. He's a character. He's up there in the right-hand corner of your screen because we are in the Land of the Lost. Yes, yes, absolutely. Motion granted. We absolutely can. Hang on, where's my stapler? Sometimes we need to bring our girl Cardi B in here. And now that we know that Cardi B was at the Patriots game the other day.
Hello.
Hello. Hello, I'm here.
Yeah, sometimes we need it. Cardi B never disappoints. She doesn't. I'm always going to find that funny. And we have an emoji for that too, Thunder Horse. Thank you. Forgot that. Cardi B is also an emoji saying hello. Next section, error of law in single justice session. Here, the single justice clearly misapplied the highly deferential abuse of discretion standard rather than the foregoing de novo principles. They found that, quote, following close review of the defendant's petition and appended materials, the Commonwealth's opposition and appended materials, including a transcript of the hearing held on September 11th, transcript knows she did not listen to the recording, and the judge's orders, this court concludes that the judge did not commit an error of law or otherwise abuse her discretion. That is completely exactly what this single justice was not supposed to do. This single justice was supposed to take the entire thing and look at it with a fresh set of eyes, and she did not do that. Therefore, in my opinion, that is why the entire panel decided to hear it. I think it's got a good chance of being overturned on appeal. I really do. Like, that is my legal opinion. I never thought this should have happened this way to begin with, but I think that the full panel on the SJC is going to hear this quickly. I think they probably won't even want to hear oral argument on it because to those of us who actually practice law, this is so obvious that it shouldn't even have been going on for this long. This is why sometimes I feel like I'm in the upside down, inside out, like insanity of Massachusetts, because this should not happen this way. And that is why so many of you that have watched the Karen Read trial with me and all of these other insane things that we see happening in Massachusetts, I need to tell you that this is not the way it's supposed to be. It's just not. And there's a little something in the corner for the trolls. I baked you some shut the fuck up cakes. There you go. It's just not the way it's supposed to happen. This is so obvious that it should just not, they shouldn't even need to hear an oral argument. They should just get the briefs in from the Commonwealth and reverse it on the law, because the law is very clear that what has happened here, there have been so many missteps along the way that this is such a travesty of justice, in my opinion, that it is just, it's obvious. Although largely academic, in light of the overarching impropriety of jailing Ms. Fitzsimmons, regardless of which law applies, the single justice also wrongly applied the basis for the surrender, choosing 58A over 58B. Section 58A, 4, setting out the conditions where a dangerousness hearing can be reopened, was not followed by the court. That provision requires due process, notice, an opportunity to be heard as spelled out in the section. Ms. Fitzsimmons was there under 58A to seeking a hearing to amend her release conditions. She was not in violation of any provision and was neither a Commonwealth nor a probation department target of a revocation or a reopening of the dangerousness hearing. The judge was the only person aware of a reopening of such a hearing where reincarceration was planned. As such, none of the procedural safeguards were honored as set forth in 58A4, i.e. notice that such a shocking result was even being considered. A right with that knowledge to call witnesses, have informed counsel, the right to testify, cross-examine, and present witnesses, and to benefit from a correct interpretation of the relaxed rules of evidence. There you go. I can't explain it to you better than that. There it is. In that respect, the court further erred when it misstated the standard for using hearsay in a probation hearing. The court improperly stated in the hearing that the email from probation is not evidence. It is an email. It's hearsay. And this is an email from a probation officer. The court gives it zero weight. And trust me when I tell you that the tone that I'm using is far kinder than the one that the judge actually used. And then we looked at the statute, and the statute clearly says you can use hearsay. The court's determination on the email from Assistant Chief Probation Officer Jeffrey January as hearsay and not evidence is an error of law. As, quote, these rules concerning admissibility of evidence in criminal trials shall not apply to the presentation and consideration of information at the hearing, and the judge shall consider hearsay contained in a police report or the statement of an alleged victim or witness. And there it is. That's the law. Massachusetts General Law 27658A4. We looked at it at length more than once. In its September 16th decision, the court asserted that hearsay must be reliable and there must be good cause for the decision not to present live testimony. In doing so, the court failed to acknowledge the abandonment of the good cause requirement as stated in Commonwealth v. Henderson, which states, quote, ordinarily, the revocation judge should excuse the witnesses. Ordinarily, the revocation judge should excuse the witness originating the hearsay information only for good cause. However, if the hearsay information satisfies the standard of substantial reliability or trustworthiness, the need to show good cause disappears. Accordingly, the court was applying a legally faulty standard to the evidence presented by the defense and should have fully credited his contemporaneous documentation of Ms. Fitzsimmons' difficulties. Ms. Fitzsimmons was deprived of all of these safeguards, hardly the embodiment of the promise in Brangen, Supra, that pretrial incarceration occurs only, quote, in carefully circumscribed circumstances and subject to quite demanding procedures. The court also did not satisfactorily consider or use the least restrictive alternatives and did not meet the clear and convincing evidence standard. Well, she didn't even consider, she didn't even want to hear it. She didn't want to hear any of it. She didn't want to hear it at all. Mr. Bradley, you're saying it's cruel and inhuman? Torture? Torture, you say? Oh, well, I certainly don't want to torture her. So I'm just going to send her back to jail. She didn't consider anything. Where 58A is an opposite, it follows that Ms. Fitzsimmons was wrongly surrendered in violation of 27658B, the only other provision available. Section 58B limits the circumstances under which a trial court judge may surrender or revoke the 58A release of a detainee as follows. Here it is. This is Section 58B. A person who has been released after a hearing pursuant to Sections 42A, 58, 58A, that's the one we're looking at, 58A, that's the one that's important here, and who has violated a condition of his release, remember she was not in violation, shall be subject to a revocation of release and an order of detention. She didn't violate. The judicial officer shall enter an order of revocation and detention if, after a hearing, the judicial officer finds, but see, we don't even get to that part. We don't even get to the if, because She did not violate. She completed the testing on the Scram device. Even Mr. January testified to that under oath. He swore to tell the truth. She was not in violation of her bail conditions. He would not violate her. In fact, he would not even notify the court that it was taking her a long time to complete the testing because he saw how much pain she was in when he first fit her with that device. And Mr. Bradel was getting ahead of it, preemptively filing a motion saying, could we try something else? Because this is really, really, really painful. She hadn't violated. She was not in violation. We don't even need to get to the if. But I'll read it to you anyway, because it's here. If, after a hearing, the judicial officer finds, 1, that there is probable cause to believe that the person has committed a federal or state crime while on release, or clear and convincing evidence that the person has violated any other condition of release, and 2, the judicial officer finds that there are no conditions of release that will reasonably assure the person will not pose a danger to the safety of any other person or the community, or the person is unlikely to abide by any condition or combination of conditions of release. And it says bold sections are relevant to instant appeal. By the plain words of the statute, orders of revocation, and detention are only permissible if 1, there is a clear and convincing evidence of a violation of release, that is italicized, and 2, there are no conditions of release that will assure the safety of any other person or the community, or the person is unlikely to comply with a condition of release. Here, the court's sua sponte imprisonment of Ms. Fitzsimmons runs afoul of the statute. Sua sponte is something that the judge just decides to do on her own. It means nobody asked for it. The Commonwealth didn't ask for her to be incarcerated. The defense obviously didn't ask for her to be incarcerated, but the court, sua sponte, on her own, just decided to throw Kelsey back in jail. That's what that means. Ms. Fitzsimmons did not violate a condition of release. She was there in good faith to avoid difficulty going forward. The Commonwealth, to its credit, recognized the situation as such and only wanted her to continue to be tested. When asked for its position or evidence, the prosecutor said, no evidence to submit other than the arguments that I talked about how the Commonwealth's belief is, in light of the court releasing the defendant, that testing be done. That's what he said. That's what he said during the hearing. There was no allegation of a violation or a request to hold a 58B hearing or any request to send her back to jail, just a request that testing continue. And it was James Gubitos. That was the ADA who argued that at that September 11th. I think it was the September 11th hearing, right? Nor did probation seek any hearing on revocation or allegation of noncompliance or notice of surrender. To the contrary, Assistant Chief Probation Officer January fully supported an alternative testing means, but was completely shut down by the judge, who became increasingly angry that he was confirming and corroborating the defense motion with his own personal knowledge. He said, as recorded at 12/17/25, volume 115, provided herewith, this is Mr. January's words. My first job when we get an incomplete test is to gather more information, which is what we do. So in response to the incomplete test, we call Elmo, we gather the information, which is she answered the alert to take the test as scheduled. Unfortunately, she was unable to complete the test because she was unable to blow as long or as hard as needed to complete the test. So ultimately at 4:20, she completes the scheduled test. There may be additional attempts in between, but ultimately she completes the test. In conjunction to the hour and 20 minutes, we also know, and I observed it firsthand, that whatever the injuries are, and I don't know, and actually it doesn't really matter to me, when I was doing the installation process and observed what was genuine pain, and then the judge interrupted Mr. January and said, any objection to any of the terms used by the probation officer? No? Okay. It was like Canoni helping baby Adam, Lally. Would you like to object, Miss Lally? Would you like to object? January continued, we have all of that information. We don't deem that non-compliant. She is attempting to take the test and she ultimately passes the test at 4:20. So with all of the information, that is not non-compliant. That's compliance with her obstacles. That's compliant with scram testing. How many times did he say it? 5 or 6? If she had missed the test, that would generate additional responses from Elmo, and that would determine whether or not that was actual noncompliance. This particular case, I don't deem noncompliance because she's complying with the scheduled program. I'm aware of pain based on my observations from the installation process. So as long as she's attempting to take the test, continues to attempt to take the test, and then ultimately takes the test, that's not noncompliance. That's someone that's, and then the judge interrupts and says, well, that's your position. That's non-compliant. It's really up to the court to determine whether someone is compliant or not with conditions of release. And then January continues. It would never be brought to court by way of a pretrial violation for an incomplete test with the information that I've talked about. So no, an incomplete test does not initiate a pretrial violation notice from our end because there are many reasons for a test to be incomplete. The goal is to test to ensure that the person is sober, and we don't deem that noncompliance. We would never, this is all in bold font starting here, we would never, we have never, and we never would in this case initiate a pretrial violation proceeding based on an incomplete test that was subsequently passed. The schedule for her to be tested is something that we discussed. It wasn't ordered by the court. The court ordered for someone to be alcohol-free, and the judge interrupted and said, what do you mean we discussed? So she knows when she's going to be tested? And January continues. I discussed with Ms. Fitzsimmons, I discussed with the defense counsel about creating a testing schedule because it's more practical to have a schedule in place. There was no schedule that was ordered by the court. There's no frequency. And then the judge interrupts again and says, it was random screens. Excuse me, Officer January. It was random screens. Now you're telling me that she's on a schedule to get tested? Is that what you're telling me? And again, my tone is far nicer than the judge's actual tone. And you know, because you listened to the recording with me. January continues, we created a schedule as we always do. Not in this particular case. We always do. And the judge said, it was random screens that were ordered. I'll get you, my pretty, and your little dog, too. When we get an order and someone is placed on pretrial conditions, that includes remaining alcohol-free with scram testing, we always default to creating a testing schedule up to 4 times a day. The only way we would not enter a schedule is if the court specifically said, I want the test to be done randomly. I don't want her to know when the tests are coming. I want the test to be done randomly. With selected emphasis in bold. Now we're going back to Bradel speaking instead of quoting what happened at the hearing. The court was incorrect and random testing was not ordered. Well, he said that a lot more nicely than I would have. There is no such order on the probation contract, and undersigned recalls no such order. Regardless, whether random or scheduled, no loophole, quote, loophole, would have been created either way for undetected alcohol consumption. The court should have allowed an alternative testing method. It is story time. This is story time, Aries girl. And I have to point out that Tim Bradel is an excellent scrivener. He's a great writer. He's a great, Betterow gets a lot of credit for his Betterow letters and such. And we love Betterow letters. But I have to say, Tim Bradel is an excellent wordsmith. His legal writing is in such a way that it makes it easy to understand. He's a great storyteller, yes. And also, he explains it so well that I don't have to explain it further, really. I don't have to dumb it down. Like some lawyers write over everyone's head that's trying to understand what they're saying. And Tim Bradel writes it in such a way that it is easy for all of us to understand. Those of us, or those of you who did not go to law school, I think that he writes in such a way that you get it, right? He repeats what's important. so you know what's important, because he emphasizes it, not too much, just exactly right. Agree? All right. Next section is the court violated the Americans with Disabilities Act. In finding that after a thorough review of all of the arguments and submissions by the Commonwealth and Fitzsimmons, that conclusion remains unchanged regardless of Fitzsimmons' claimed physical limitations, the court violated Title II of the Americans with Disabilities Act, prohibiting discrimination against people with disabilities in pretrial services without reasonable modifications. Something else that we were screaming during the course of these proceedings. And once again, we all feel heard. At the time the condition was imposed, Ms. Fitzsimmons had recently sustained life-threatening injuries, including gunshot wound to the right chest, hemothorax with retained bullet fragments in the right upper back, moderate right hemothorax requiring chest tube placement, right middle and lower lobe pulmonary contusions with active bleeding, grade 4 hepatic trauma with active bleeding from the right hepatic lobe, that's the liver, comminuted right posterior 12th rib fracture, and a right anterior 11th rib fracture at the costochondral junction. Conjunction junction, what's your function? Do you guys remember that? The U.S. Department of Justice Civil Rights Division has directly addressed the ADA's applicability to this situation in its information and technical assistance on the ADA guidance letter as follows. Title II of the Americans with Disabilities Act, ADA, protects people with disabilities from discrimination in state and local government services, programs, and activities, including law enforcement agencies, justice system entities, and juvenile and adult correction agencies. The ADA requires criminal justice entities, including attorneys, courts, jails, juvenile justice entities, police, prisons, prosecutors, and public defense attorneys to avoid discriminating against people with disabilities. It seems so obvious, doesn't it? And yet here we are. Here we are. She was thrown back in jail on what day? September 11th. And tomorrow is November 11th. She's been in there for an extra 60 days. That's the exact amount of time that Aiden Carney, Turtle Boy, was in jail after he was set up to be thrown in jail. He spent 60 days in jail too. This is another extra 60 for Kelsey. Based on what? Bullshit. I have a button for that. Hold on. Entities must ensure that people with disabilities are treated equally in the criminal justice system and that they have equal opportunity to benefit from safe, inclusive communities. Non-discrimination requirements, such as the obligation to provide reasonable modifications to policies, practices, procedures, and the obligation to take appropriate steps to communicate effectively with people with disabilities, also support, 18 also support the goals of ensuring public safety, promoting public welfare, and avoiding unnecessary criminal justice involvement for people with disabilities. As a result of her gunshot wound, Ms. Fitzsimmons has severely diminished lung capacity and suffers acute pain when attempting to inhale or exhale deeply. Her treating physician has medically opined that, quote, a fracture of the 12th rib can cause pain that may persist for several months after the injury. The severity and duration of pain following such a fracture vary, and it is difficult to predict how long symptoms will continue in any given patient. Additionally, retained bullet fragments can also cause chronic pain that can be exacerbated by movement, such as deep breathing. Thus, an individual suffering from the conditions in which Ms. Fitzsimmons has would make an individual medically incapable of blowing with sufficient force or duration to activate or register a reading on a scram breath device. Despite these limitations, a scram device was installed on September 8th of 2025, footnote 9, which reads, upon witnessing Ms. Fitzsimmons' inability to comply with the device's demands due to her medical condition, Assistant Chief Probation Officer Jeffrey January, shout out to Jeffrey January, attempted to bring the matter right back to the attention of Judge McCarthy Nyman, the presiding judge who had imposed the condition. However, Judge McCarthy Nyman had already left the courthouse for the day, and no immediate judicial relief was available. He tried to tell her, but she was gone for the day. She checked out. On September 10th, 2025, Ms. Fitzsimmons, through counsel, filed a motion for immediate relief from Scram, which was met with Ms. Fitzsimmons' immediate incarceration by the court. On September 11th, 2025, immediately following the revocation, she filed her motion for reconsideration, which provided the email from probation and requested reasonable accommodations, including an alternative alcohol monitoring method, random urine screens. Finally, on September 15th, 2025, Ms. Fitzsimmons, through counsel, filed a supplemental filing, but the request for reconsideration was denied without a hearing. Of course it was. In doing so, the court explicitly referenced but ignored her physical limitations in the reconsideration denial opinion. Yeah, she didn't even address it. She didn't even talk about it at all. Not even a mention, not even a word, no big whoop, no biggie. What do you mean she's got a collapsed lung? She had a chest tube inserted and all these fractured ribs and a lacerated liver and all these surgeries, and she was airlifted in the hospital for so what? No big deal, no big whoop, no biggie. I'm not even going to address it. I don't want to torture her, so I'm just going to put her right back in jail. Ridiculous. The court revoked Ms. Fitzsimmons' bail and ordered her detained solely on the basis of her noncompliance with a physically impossible condition. Under Title II of the ADA, no qualified individual with a disability shall, by reason of such disability, be excluded from participation in or be denied the benefits of the services, programs, or activities of a public entity. Prayers up for Kelsey. Great idea. See some prayer hands in the chat. The judiciary, including courts and probation, to be within the meaning of the statute and must comply with its mandates. We just read the statute. It's in there. It's in there. We saw it. We read it together. There are numerous alternative alcohol monitoring options available, including transdermal, Scram bracelets, non-breath-based. Footnote 10, we pulled up the Scram website. We looked at it. A transdermal Scram bracelet, although not currently available in Massachusetts, is like a breathalyzer for the ankle. The Scram continuous alcohol monitoring bracelet provides 24/7 transdermal alcohol testing for hardcore drunk drivers, high-risk alcohol, and domestic violence caseloads. By automatically sampling the wearer's perspiration every 30 minutes, the Scram Cam bracelet eliminates testing gaps and encourages accountability. Scram Cam not only supports sobriety, but also results in higher compliance rates with court orders and increases community safety. And that is from the Scram website. And we pulled it up and looked at it. There are numerous alternative alcohol monitoring options available in addition to the one we just read about, the transdermal Scram bracelet, random urinalysis testing, and in-person probation check-ins. Each of these is medically appropriate for the petitioner and allows monitoring of substance use without violating the ADA or imposing impossible requirements. If this court deems conditions necessary for release, it is not too much to ask for the court to accommodate Ms. Fitzsimmons' conclusively demonstrated disability with an alternative testing method and not violate federal disability law to enforce a dubious procedural position. Conclusion. The court should have granted release on personal recognizance with standard stay-away orders. The court clearly dispensed with the safeguards that bail be revoked only after finding a violation of terms and that there be no combination of conditions that would allow the defendant's release. The court did not further the bail statute's purpose of establishing the right of the accused in most circumstances to be admitted to bail. If this court believes there should be conditions set, there are ample alternatives to Section 58A incarceration for Ms. Fitzsimmons, all of which were assiduously avoided by the trial court. I mean, there it is right there. For the foregoing reasons, Ms. Fitzsimmons respectfully requests that the SJC, number one, address the bail determination de novo, consistent with the applicable case law, means look at it with a fresh set of eyes all over again, start from the beginning. Number two, and number two, grant Ms. Fitzsimmons liberty with personal recognizance and a stay away order from the alleged victim under Section 57, no finding of dangerousness required, or Section 87, bail terms imposed with agreement of the defendant of the bail statute, and vacate the balance of the trial court order, including the provision handicapping the probate and family court from handling the custody and visitation decisions in the case. Wait a second. Vacate the trial court order, including the provision handicapping the probate and family court from handling the custody and visitation decisions in the case. And or 3, grant other such non-incarcerative relief in the alternative if the court deems 58A conditions necessary. And 4, send the case back to the Essex Superior Court before a different judge for the reasons set forth above. She doesn't need a new judge. I guess the finding of dangerousness is what they are referring to when they talk about handicapping the probate and family court from handling the custody and visitation decisions in the case. Because this court has already deemed her dangerous, and so the probate and family court cannot then give Kelsey any type of custody or visitation because of that finding, although it was not more fully set forth in this brief. Did I miss it somewhere? I don't know. I don't think I did. Yeah, she ruled to stay away from the baby, right? But that doesn't give, I guess the probate and family court is handicapped. They don't have concurrent jurisdiction. They can't overrule the Superior Court decision, right? Wherefore, Ms. Fitzsimmons respectfully requests the Supreme Judicial Court justices enter the appropriate orders above. XOXO, Kelsey Fitzsimmons by Timothy Bradle, the Silver Fox, and Martha Coakley, the former Attorney General for the state of Massachusetts. And we stand with Kelsey. Affidavits of service, etc., etc. Let's go back to the chat and see if there's anything here that you need further explanation on. But I think this was written so perfectly, and I explained it throughout so much. I don't know that there's many more questions that you could possibly. If you do have them, by all means, ask away. Susan C. gifted 5 memberships. Thank you, Susan. That is so very kind and generous of you. I gotta close some of these windows over here because I'm getting a draft. Ha ha ha. And also, it's making my computer glitch. Thank you, Susan, for gifting 5 memberships. I appreciate you so much. And Kyle's here, and he says, if I were one of these folks, public trolls would be the last things I do. It's amazing to me. It's so funny. They clip all my stuff, and then they put me all over Twitter, thinking that I said that I could find out who they are by clicking on their name, that I could find out their IP addresses that way. But I mean, anybody with half a brain knows that just because you hide behind a fake name doesn't mean that people can't find out who you are. There are ways, right? Aren't there ways? I mean, Kyle, there's ways, right? Of course there's ways. Didn't work out so well for Jennifer Coffendorfer when she tried to make me look like an idiot, but I don't know. Maybe she's behind one of these accounts that's been trolling me lately. I don't know, with a fake name. I don't know. You guys know anything? Leave the drama at the door. Thank you for your super sticker. And Gigi is back, and she gifted another 10 memberships because you know why? Because she is the most blessed Gigi on earth, and she's amazing. And thank you, Gigi. Thank you, Jersey Girl. Oh, Jersey Girl, shoot me an email. Shoot me an email, Jersey Girl. She says, I'm in IT. Oh, there are ways. And she's laughing. I know. This is what they do. I said something one day like, you guys hide behind fake names and you think that your IP addresses can't be found? And then they clip that and they make it sound like I said something. I don't even know. But I mean, is that really how stupid these people are? Like, are they really that stupid? Are they really that stupid? I say yes. I say yes. But, All right. Gigi gifted 10 memberships. I think I just thanked you, but I'm thanking you again. And Janelle is here for 24 months and says, sometimes I long for the earlier days when there weren't so many trolls spewing their hate. You're the best, Mel. Love your coverage of everything. Oh, you're the best too. 24 months. That's a long time. That's like since the Kevin Costner days. And also, look, if you don't have haters, then you're not, if you do have haters, you're doing something right. Because you're obviously making an impact and people are getting very afraid, right? Like what do you care? Why do you, if I have no effect on, I don't know, if I don't make any sense or I'm just full of it, people will be able to find that out. You don't need to get out there and tell people about it. But if you're trying so hard to discredit me, it's because you're really afraid of what I have to say. Right? Or, I mean, I'm really just reading court documents and giving you my opinion. I think this will be overturned by the SJC full panel without oral argument. That is what I think will happen. Oh, please. I don't know anything that happened on Walsh. Did somebody, Law Nerd said, can you give a small update on Walsh? I don't know if they've come back with his competency determination yet. If they have, it hasn't landed in my inbox. So I don't know. Hold on. Thank you, Janelle. I love you even more. Denise, go blue, member for 24 months. Yay. Love being part of the cupcakes. I love that you've been here for 2 whole years. And Ms. Jill says, Melanie screams of retaliation to me. Yeah. Yes. Thanks, Ms. Jules from Florida. Space Dudette. Thank you for being here for 11 months. And Priscilla says 6 months. I've been watching longer. Thank you. Thank you, Priscilla. Well, here's the thing, because, chatting is a privilege and not a right. What you should do, because the more of these trolls come around, the more I'm going to have to lengthen the time of being a subscriber to chat. And so subscribing is free. You just got to hit that subscribe button below. Do it now if you want to chat, because chatting is really fun here. You guys are called the Snark Tank for a reason. And so do it now. It's free. Just hit the subscribe button. 20% of people that watch my videos are not subscribed. And so that's a very good rate, actually, of non-subscribers watching. But you should really smash the button because, it helps the algorithm and all. And plus, we're just spewing truth here and facts. It's just facts and truth. A lot of people can't handle the facts and truth, and that's why they're running scared. And Gigi says, we need a shirt with a no biggie, no big whoop. My daughter is attempting to make one. All right, right on. Thanks, Gigi, for your 10. Diane G is here, and she gifted 5 memberships too. You guys are awesome. Awesome. Thanks, Diane. Pinky Promises says, if Kelsey was breastfeeding and lost the ability to produce milk because of trauma, would that have been included in this motion, or should it have been included? No, I think it's not relevant for what they are asking the court to determine. Now, if there were ever some sort of civil suit in the future because of, false imprisonment or such things like that, violating Kelsey's civil rights, at some point in the future, could that be included as an element of special damages in any civil lawsuit? Yes, it could, but we're getting way ahead of ourselves right now. But I like the way you're thinking. And that is what happens. I don't know if they're allowing her to pump in jail. I don't know if they have if they have the means for that, and if they're allowing it. It has never been brought up. It is a great point. But if you don't pump, anybody who's ever breastfed, if you don't pump, you will stop producing milk and it'll dry up. And that makes me very sad. Thank you very much. Pinky Promises. Leave the drama at the door. Thank you for your super sticker. And Tony says, I just want to say how much I appreciate you, Mel. Oh, I love you with all of my heart too. Thanks, Tony 76. Life at a Shy says, Proctor told Internal Affairs Karen Reed told her mom about her health on the same day he texted his friends about the balloon knot. LTA exposed the IA meeting with, okay. I have the entire Internal Affairs report that I went over a very long time ago. We went over some of it again the other day. I can't really comment on this because I don't have it in front of me, but thanks for letting me know, and I can go back and look for it. Thanks for your 5. And Gigi with a $50 super chat. Says Melanie, here in Texas, our police officers and firefighters make a calendar every year and donate the money to charity. So glad Massachusetts does not do that. I have yet to see anyone I would ever want to see in a calendar. I'm trying to be nice. Ew. Thank you, Gigi. You're 50. You're amazing. And so amazingly generous. And you're totally awesome. I appreciate you so much. Beauty for Ashes became a member. Welcome. Just Breathe by Pearl Jam. I love that song, Miss Jules. Thank you. I love it. I love it when Eddie Vedder sings it. I love it when Dave Matthews sings it. I love that song all around. Thank you for your 10. And Mozzie is here from Down Under. And she says, do you think that Massachusetts judges are against Bradel because he's representing Turtle Boy against the corrupt Commonwealth? You know, I don't think so. I mean, I don't think so. I think that we're seeing some very unusual treatment of him, but I don't think that that is playing. I would hope that that would not be playing a role in because you can't hold an attorney's clients against him and treat him a certain way because he represents a certain person. I mean, everyone's entitled to a good defense, right? And so I would hate to think that that's what's happening. I personally don't think that that's what's happening, but I can see how some people would think that. Does that make sense? You can see it all the way from Down Under. Miss Jules from Florida is here and she gifted 5. Thank you. Thank you so much. And to the 5 that were so randomly gifted, you're awesome. I think we're just seeing a lot of judges doing things that are just so out of the realm of what's normal in Massachusetts specifically. But listen, we're covering cases in Oklahoma that are also insane. And we're covering cases in Arkansas that are also insane. Aaron Spencer and others. And Judge Barbara Elmore just letting grapists out on very low bail. And then they go out and grape again. We saw that recently. Another case in Arkansas. Are we out of the woods yet? No, Jessica, we're not. Are we in the clear yet? No, we're not in the clear. We're not out of the woods. Neither, Jessica. Just a little technical perjuries here and says, coming up on a year soon. Love Melon Cupcakes. Love you too. And cupcakes, free the sidebars. Is that what that says? Free Kelsey Fitzsimmons. Well done. Thank you, 3 Clerk Monty, for hanging out for 11 months and Sunflower Day for 17 months. Pearson's Costner. We'll never leave facts and truth. Thank you. Where's my stapler? Thanks for your 5. Why in the statements in the brief was all the first parts in question marks? Oh, because those are the issues. Those are the issues before the court. And it's a question of law that the defendant wants the appellate court to answer. And that is why. That is a great question. No, that's a great question. Those are questions of law that the defendant wants the appellate court to entertain and to answer. And so those are the issues. And that is what appeals are all about. It's about questions of law. And so thank you for your 5. That's a great question. That girl says there's no place I'd rather be. No, ain't no place I'd rather be either, girl. Free Kelsey Fitzsimmons. Thank you for being here for 10 months. And Amy in Arizona gifted 10 memberships. You guys are so super generous tonight. Super, super generous. Thank you, Amy, for gifting 10 members. And to those who are randomly gifted, you guys are awesome. Welcome. I think you're going to like it here. Like Natty A. Bubbles says, I love your channel and all the cupcakes. Thanks for hanging out for 6 months. And Sherry Ann for 13 months. You guys are really like, there's a lot of loyalty in this chat. A lot of loyalty. Thank you. Thank you for being here for 13 months, Sherry Ann. And Amy says, my work is interfering with my live time. Oh, you're in Arizona, so it's you're a couple hours behind. And so that's okay. You can always watch on replay. Just always smash the button whenever you can, the like button. And Christy Painter's daughter says trolls are tacky. Membership with Melanie is cool. Yeah, I mean, I would say that you're being nice by saying tacky. They're really vile. Like they're really vile. Like the things that you didn't even see because the mods are so quick on the button. The things that you didn't even see were like vile. Thank you, though. I appreciate you, Christy. And Diane gifted 5 memberships too. You guys are awesome. You guys are awesome. I did not hear about the Rust saga. I did not hear that yet. But wait, there is something else that I want to talk about to you. I'll talk about with you, not to you. I don't want to talk to you. I want to talk with you. Hang on a second. Thank you, Bull Cut Lineup, for buying me a matcha latte. Says, thank God you're here. I love what you do and how you do it. Thank you. Thank you, Bull Cut Lineup. That's a great name. I appreciate you very much. All right, here you go. Thank you to Zoe, our statistician, who is telling me this information regarding the sidebars in the Karen Reed trial. Zoe's amazing. The total number of sidebars for Commonwealth versus Karen Reed trial 2 is, take a guess, 204. The judge called the parties up to sidebar 77 times. Attorney requested sidebars. I mean, Zoe even like broke this down even further. The Commonwealth total was 42. Hank Brennan, 35. Adam Lally, 7. The defense total was 85. Alan Jackson, 57. David Unetti, 5. Bob Alessi, 23. Elizabeth Little, 0. And Zoe says, I plan on going back and watching trial 1 over to gather the statistics for comparison. I just haven't willed myself to suffer through that exercise yet. I don't know, Zoe. Maybe we should do that. Maybe we could assign it out. We could assign it out. And like people could volunteer to like watch for one day. How many days of trial? What was the first trial? 30, something like 30 days. Yep. 204 sidebars in trial number 2 alone. Props up for Zoe. Props up for Zoe, everyone. She's amazing. She's doing the Lord's work out here, doing the Lord's work for everyone. Elaine, thank you so much for your $100 Venmo. Says, let's go. Can't wait to hear all the latest. Thanks for all you do. You're the greatest, Elaine. You're the greatest. Such a really, really kind and generous supporter of this channel. Always, always, all the time. So great. All righty. In just trial 2. Yeah, 204. Corey's going to need a wheelbarrow, says Al Dente. Corey's going to need a wheelbarrow. Deanne loves it here. Thank you. Strange Credulity gifted 5 memberships too. There's got to be like at least 50 new members tonight. You guys are amazing. Thank you. Venus Blue Trial Bunny says, Mel hitting us with the facts tonight. 204 sidebars, says Jessica. Is that normal? No. No, it's not. You know why, Jessica? Because most judges require you to say, objection, hearsay. And it'll be sustained or overruled. You won't have to come to sidebar to explain your grounds. It's so ridiculous. No, it's not normal. Think about the other trials that we watch. I don't know, like just what did we cover? Gavel to gavel. Sarah Boone, I think, was one. Not a lot of sidebars in Florida. They get it done in open court, right? No, it's not normal. Thanks, Jessica, for your 5. And the most blessed Gigi on earth is back again and says, my daddy, who I miss so much, would tell me, if someone takes the time to put you down, you are doing something right, my beautiful girl. Oh, your daddy's awesome. Your daddy was awesome. Heaven just got a whole lot more awesome if you're saying that that's where he is right now. That's amazing. Okay. Let's talk about something. What I need to do here first, though, is when I'm prepping these shows for you, I open a whole bunch of tabs on my phone. And then when I'm live, I'm on the Ethernet, so I can't like teleport this from my phone to my thing because it doesn't really work like that. Hold on a second. This is it. All right. Nope. That's the Jesse Butler thing. All right. What I want to talk about right now, because I didn't know this until like yesterday, and a lot of people have been asking me to cover Justin Root for a very, very, very long time, and we just like things just kept happening, and so I just never had a chance to cover the Justin Root case until like while I was on vacation, and what I learned has me outraged and horrified. And I imagine that there's a reason that I just started to look at this, because everything always happens for a reason, right? And there's no such thing as coincidence. And sometimes you cover something at the right time because of the time that it needs to be covered. And so what I did not know about the Justin Root case is that the police officers, oh, well, thank you, ESPN, for wanting to give me notifications about the score of the Ranger game. And the Rangers are up 3-1 over Nashville. So that's awesome. Oops. Hold on a second. I don't know. I was on Do Not Disturb, but hold on. Okay. What I learned has horrified me. If you do not know about this case, you're going to learn about it now. You too may be horrified. And what is so horrifying about this is that the police officers who shot Justin Root 31 times were cleared due to an investigation by Proctor, Bukhenic, and Fanning. Proctor, Bukhenic, and Fanning cleared 5 Boston police officers in the shooting of Justin Root. Okay, so what we're going to do tonight is a broad overview. It happened 1 year before the murder of Sandra Birchmore, 2 years before the murder of John O'Keefe. And if you're wondering why would Michael Proctor give up everything? Why would he give up his livelihood, his career, his family, his pension, all of it? Why would he give it all up for, I don't know, Brian Albert or the other people involved? Why are these people attacking me relentlessly on Twitter? Because I have so many things to say. Why? Well, first of all, let's do this. Let's go to the family of Justin Root. I believe started this this website, and his sister's name is Jennifer Root Bannon. She had a civil lawsuit pending. I haven't dug into it enough yet to figure out, but I think it's been dismissed. Jennifer Root Bannon, if you're out there and you want to talk to me, please reach out to me. I would love to talk to you about your brother's case. He is gorgeous. He is so handsome. He did not deserve to die while he was in the throes of a mental health episode and was shot 31 times at point blank range by a bunch of Boston police officers. And I'm horrified by this, and I'm sorry that I didn't look at it sooner, but I think there's a reason I'm looking at it now, and that is because of Proctor's involvement. Proctor, Bukhenic, and Fanning. Here's Justin's story, as written by his sister, who is the only one fighting for him, okay? Because there's never been any criminal charges brought against any of these officers. And here, you can find this, because you like receipts. This is justonroot.com, JUSTON root, ROOT.com. I'm gonna read you the facts now. It's a horrible case, and let's first take a look at where I was before. Hold on. Here's Justin right here. Okay, he's a looker. He's a looker. Gorgeous, gorgeous. This is Justin Root. This is what happened. Justin Root's story, a demand for justice. And this horrific killing occurred on February 7th of 2020. Think about this. February 7th of 2020. Sandra Birchmore was February of 2021. John O'Keefe was murdered January 29th of 2022. This is infuriating and sad. Ready? Here we go. On February 7th of 2020, Justin Root was just steps from his longtime mental health clinic. Hi. Do you need something? Hold on a second. Okay. All right, here we go. On February 7th of 2020, Juston Root was just steps from his longtime mental health clinic located next to the Brigham and Women's Hospital, BWH, campus, where he had received treatment for nearly a decade. When a hospital security guard, after briefly speaking with him and shaking his hand, falsely reported that Juston had threatened to shoot him. The security guard later recounted observing something clear in Juston's waist that he thought could be a gun. In reality, it was an oversized, clear plastic paintball marker with a chimney-like piece protruding above the waistline, off to the side and mostly concealed by his long dark coat. Juston had committed no crime and had walked away peacefully. As they waited for Boston police to arrive in response to what they claimed was a, quote, dangerous gunman, the unarmed BWH security guards began agitating and escalating the situation rather than diffusing it. Meanwhile, a security officer from the nearby mental health facility, standing approximately 60 feet away, recognized that what Juston had was clearly a toy. Here's some body cam still shots that we'll look at after we read the whole story. When Boston police arrived, they opened fire within minutes, discharging 15 rounds. As the first officer approached, Juston, struggling to communicate due to his psychiatric disability, repeatedly shouted that he was with law enforcement, a known symptom of his mental health condition. With his firearm already drawn, and without any attempt at de-escalation, the officer closed the distance while Juston's back was turned, advancing to within 36 inches. When Juston turned and saw the gun pointed at him, he pulled out an oversized, clear plastic paintball marker from his waistband. The officer immediately fired, shattering it and leaving only the clear handle in Juston's hand. Together, the two responding officers fired 15 rounds. One bullet ricocheted a significant distance and struck a hospital valet in the head. Despite being seriously wounded and bleeding, Juston managed to get into his car and drive slowly away. 4 Boston police cruisers followed him at a low speed, yet none ran his license plates, a routine check that could have identified him and provided crucial information. Instead, without provocation, an officer performed a high-risk pit maneuver typically reserved for high-speed pursuits. Do you know what a pit maneuver is? Pit maneuver is when a cop car rams into you to drive you off the road. Terrified and bleeding, Juston panicked and fled, fearing for his life. 7 minutes after being shot multiple times, Juston crashed his vehicle and staggered out. Having lost nearly 2,000 cc's of blood before collapsing in a mulch bed near a supermarket parking lot. He was unarmed, barely conscious, and clearly in urgent need of medical care. A civilian EMT rushed to his side to provide aid, but officers quickly approached with guns drawn and ordered her to leave. Fearing for her safety, she reluctantly left his side. Seconds later, one officer kicked Juston before the officers performed a semicircle. Seconds later, one officer kicked Juston before the officers formed a semicircle around him and fired 31 bullets at point blank range, despite him lying on the ground, covered in blood, clearly incapacitated and unarmed. He posed no threat. He never stood a chance. Only one body-worn camera was recording, but its lens became obstructed, likely by the officer's arm, and the footage goes dark just before and during the shooting. Just 30 days later, Norfolk County District Attorney's Office cleared the 6 officers involved. However, critical evidence, including the EMT's testimony about Juston's condition before he was killed, was excluded from the final report. Many officers met as a group before giving their witness statements, which were recorded 5 days after the shooting. The Norfolk County District Attorney's Office, the Norfolk County District Attorney's report is inadequate, incomplete, and lacks transparency. What it doesn't say on this website by Justin's sister is that the 3 investigators who investigated the Boston police officers in the shooting were Michael Proctor, John Fanning, and YURI Bukhenic. And look, the officers met as a group before they gave their testimony, because they need to get their stories straight, right? And get the timeline in order, right? And then they actually did record these interviews, though, 5 days later. Over 5 years, the Root family has demanded a thorough, independent investigation free from the bias and influence that have tainted the process. We call for a timely, transparent, and impartial investigation into Justin's death. Well, what do you think could be in Proctor's phone, if anything? What, if anything, could be contained in Proctor's total phone extraction regarding the assassination of Justin Root? Anyone? Bueller? Here you go. Boston police shot 15 bullets at 9:23 a.m. on 2/7/20. You can go to this website, and this, obviously, this is the family story. Oh, look, they found some evidence markers. Could you imagine? That's the family story, okay? I don't have any of the police reports. I would love to see them. I would love to see the witness statements. I would love to see all that stuff. If anybody has it, please send it to me. Contact me, because I would really want to do a deep dive into this. But in order of, fairness, I'm going to pull up a February 13th, 2023 article from Mass Live. And I'm going to tell you Michael Morrissey's side of the story. Okay? This is from Mass Live, and this is February 13th of 2023. No criminal charges for Boston police who shot and killed Justin Root, DA says. So here's one of the police officers, David Godin, Godin. It says here, Justin Root points his gun toward Boston police officer David Godin. It was a toy. This toy is a paintball marker. Near the intersection of Vining Street and Fenwood Road. So the reason that this was investigated by Norfolk County is because it happened in Norfolk County. I think this is Brookline, and we learned that Brookline is Norfolk County. Here's the paintball gun found inside his car. Justin Root wore a holster at the time of the shooting on Route 9 in Brookline, according to the Norfolk County DA's office. Here's a picture of it. Justin Root's car appears at the scene of a crash on Route 9. Yeah, they ran him off the road. Look, there's his car. And after he crashed his car, he was still able to get out. He was still alive. He was still walking around, and then he was assassinated and shot 31 times. Here's a photograph of the mulch area on Route 9 in Brookline where the shooting of Justin Root took place. They're not denying that they shot him. A black handgun was discovered under Justin Root at a mulched area on Route 9 in Brookline. This is also a toy. They don't want to tell you that in the article. And here's Justin Root fleeing his damaged car on Route 9 in Brookline toward a mall parking lot. It's kind of a furry picture, a fuzzy picture, so I can't really see him fleeing unless this is him over here on the right side. That's what happened after they did the pit maneuver. Here's his car. But let's hear what Michael Morrissey had to say about it. Yes, thank you, me, myself. There was an EMT, right, who ran toward him after he left the car and collapsed. He clearly wasn't dangerous. He was clearly still alive. And then yep, exactly. I read that part. They ordered the EMT to back off. Some of that I found in the civil filings, which I did read some of the civil filings. Let me just get rid of these pop-ups here. Authorities will not pursue criminal charges against the Boston police officers involved in the deadly shooting of a man who pointed a BB gun at police outside a Boston hospital in February of 2020, according to an announcement by Suffolk County District Attorney Kevin Hayden on Monday. An independent investigation by special attorney. Oh, so wait, there was an independent investigation. Hold on. I got ahead of myself here because I wanted Marcy's story. And that was like in 2020. Hold on a second. They called upon another DA to look into it. So hang on a second. Hold, please. All right, this is from Boston.com. Oh, except it's not found. Okay, of course it's not found because of course they just deleted all reference to this, right? So of course you can't find it anymore. Hold, please. Yeah, Norfolk District Attorney had it all tied up by March. So hang tight. There's a lot of information on this, but we've never covered it. And so he closed the books on this. Michael Marcy closed the books on it within weeks. And then the Boston Globe did an expose apparently on it. And then apparently there was a special investigation by another district attorney from Suffolk County. So we'll do the special investigation since I already have it pulled up. And then we're going to have to go back and cover this more in depth if you guys want to, because I think we should. Because it just made me think, what could be in Proctor's phone? What could be in Proctor's phone about Justin Root, in addition to so many other cases? How many people are sitting in prison right now because of the investigation that Proctor and cronies did? Right? So this was 2023. No criminal charges for Boston police who shot and killed Justin Root, according to the special investigating DA. Marcy emails. There could be so much other stuff. Authorities will not pursue criminal charges against Boston police officers involved in the deadly shooting of a man who pointed a BB gun at police outside of a Boston hospital in February 2020, according to an announcement by Suffolk County District Attorney Kevin Hayden on Monday. An independent investigation by Special Assistant Attorney John Dawley into the officer-involved shooting of Justin Root, 41, of Mattapan on February 7, 2020, found that no officer should face criminal charges as a result of the incident, which began when police responded to a 911 call of a man with a gun near Brigham and Women's Hospital. Hayden said he concurred with Dawley's findings and conclusions not to pursue charges. Prosecutors from Norfolk County cleared the 5 Boston police officers and 1 Massachusetts State Police Trooper of wrongdoing in the incident in March of 2020. And here's the article that I was looking for initially. So here it is. This is from August 11th of 2020. Norfolk DA clears 6 police officers in shooting of Justin Root, man with replica gun, who led authorities on chase from Brigham and Women's Hospital. Okay. This was originally published on March 9th of 2020. So within 4 weeks of the assassination of Justin Root, Michael Marcy cleared everybody. Here you go. Prosecutors cleared 6 police officers of wrongdoing in the fatal shooting of a man in February who led authorities on a chase from a Boston police hospital to Route 9 in Brookline with what appeared initially to be a handgun, but was later determined to be a replica firearm. Justin Root flashed a gun at a security officer at Brigham and Women's Hospital shortly after 9 a.m. on February 7th. The 41-year-old Mattapan resident then fled the scene, leading authorities in a pursuit from the intersection of Fenwood Road and Vining Street in Boston to the intersection of Route 9 and Hammond Street in Brookline, where Root crashed his Chevrolet Volt, authorities said. Root exited his vehicle and fled on foot to a mulched area at a Star Market in the area before police arrived. Officers ordered Root to show his hands and get on the ground. The 41-year-old instead reached for what appeared to be a handgun in a shoulder holster he was wearing. Police then shot and killed Root, according to Norfolk District Attorney Michael Marcy's final report on the use of force. That's what I want. I want Michael Marcy's final report. Apparently it's 7 pages. If anybody has it, give it to your girl. Thanks. In light of the consistent narrative of events emerging from law enforcement interviews, video footage, audio recordings, and civilian witnesses, for each of these 6 police officers, I find that the use of force by police in Brookline was objectively reasonable and justified, Marcy said in his report, which was released on Monday. What police thought was a firearm was subsequently found to be a Crossman C11 BB gun, according to Marcy. Boston police officers David Godin, Brenda Figueroa, Corey Thomas, Joseph McMenemy, and Leroy Fernandez, as well as MSP Trooper Paul Keneally, shot Root 26 times. The incident lasted less than 3.5 seconds, Morrissey said in his report. The suspect was taken to Beth Israel Deaconess Medical Center in Boston, but he did not survive. Root's cause and manner of death were determined to be homicide by multiple gunshots from law enforcement weapons, according to the DA. Well, at least they got that going for him, right? At least the medical examiner determined it was a homicide and it wasn't undetermined. Prior to the shooting, Godin encountered Root at the corner of Fenwood and Vining. Root approached Godin, with what appeared to be a handgun, and aimed it at the officer. Godin gave the 41-year-old instructions to drop the gun, raised his own weapon, and retreated, the DA said in his report. Officer Godin fired his weapon and fell backwards on the sidewalk, Marcy's report said. Root began to struggle with Officer Godin on the ground. Boston police officer Michael St. Peter, who was at the scene, observed the 2 men struggling, heard the shots fired, and saw Root standing over Godin with his gun pointed at the officer. Not knowing the man on the ground was a policeman, St. Peter fired at Root. 15 shell casings were found at the scene, according to Marcy. A 49-year-old valet employee was struck in the head by a bullet during the incident, Marcy said. The worker was discharged from the hospital. Oops. The worker was discharged from the hospital roughly 2 weeks later after being critically injured. Right. I think what they originally said was that Justin Root was the one that shot this person in the head, but that's not what happened. What happened was a bullet ricocheted. One of the officer's bullets ricocheted and hit that worker in the head. After being shot by St. Peter, Root limped to his car and drove towards Huntington Avenue and Route 9 before entering the roadway and traveling west on the highway. Authorities were informed someone had been shot and the area near Brigham and Women's was locked down, according to the DA. Root's car accelerated past 70 to 80 miles per hour before striking several cars near the Star Market parking lot. The Volt was traveling 90 miles an hour 3 seconds before the crash, the DA said. The suspect exited his car and fled on foot. A female patient in the shopping area began to approach Root after he fell as if to render assistance, according to Marcy. At that point, the police had arrived. Police commanded the woman to get away from Root, Marcy said in his report. Officers also began shouting numerous commands to Root to show his hands and get on the ground. Body camera footage and accounts from bystanders confirmed that several orders were shouted by officers, according to the district attorney. However, Root did not comply with the authorities' commands. Jackson Coate is a breaking is a breaking reporter. Okay. So there's that. Peter Murphy is here. Peter Murphy says Justin Root case is indefensible in my opinion. I know it in its entirety. You know, Peter, I read the decision on the motion to dismiss in the civil case, and it was like that judge, like that decision was way out there. And so many things about it were wrong. The judge kept referring to the gun as a gun. It's like it was a BB gun and it was a paintball. But it's another example of cops and DAs covering for other cops, right? Michael Marcy also has not filed any charges against Matthew Farwell. Fanning is the one who quickly cleared Matthew Farwell in the murder of Sandra Birchmore, despite the fact that there were people. One of Sandra Birchmore's friends actually called Stoughton PD to tell them about this, right? They covered for Farwell. It took the FBI to get involved. But it just makes, is there any connection between what happened here and the covering, maybe, of some Boston police officers and the fact that, oh, Brian Albert's a Boston police officer too. Thank you, Matrix Media. Thank you, Matrix Media. It's 12 pages, so I'm gonna have to use it in the next show that we do on this because we're not done. Thank you, Matrix Media. I got it. But what I want to do is put something a little bit more thorough together. So thank you for sending it to me. I will use it. His sister is in the chat. Hi, Jennifer, is that you? Are you here? Yes, I got it. But what I need to do is put together more of a presentation because this is just a last minute add-on to tonight's presentation. And I want to have more information and more facts about it. And I want to see Proctor's reports, and I want to see Proctor's witness statements, and I want to see what Fanning did, and I want to see what Bukhenic did. And Magnolia Gypsy says Fanning supposedly had nothing to do with Karen Reed, but was in charge of operations at the courthouse, possibly the jury, and was CC'd on a whole lot of emails. But he was also the boss of Proctor, right? He was the boss of Proctor. He's Proctor's supervisor. So, we are just one. Is this Jennifer? Jennifer, I read a large part of, thank you for posting a lot of the file on your website, which I think is amazing. And I got into part of the motions to dismiss. And so if you want to reach out to me by email, my email is in the show notes below. It's fanbase@mlittlelaw.com, fanbase@mlittlelaw.com, and tell me who you are. Prove it. What I want to know is, has the entire civil case been dismissed? Are there any appeals pending? Because I think what happened to your brother is an abomination of justice, and I'm outraged by this. And I can't help but think that there may be some connection, and there may be some things that are going to be found in Proctor's phone that might shed some light on what happened to your brother. And we also know from the KELSEY FITZSIMMONS case that perhaps excessive force is not something that is so foreign to these police officers in Massachusetts. And yes, we just found our next movement. Thank you, Serenity, RPH. Found it. And let's just go back to see how beautiful this man was. Hold on. And his music. He's a musician too. Hold on. I want to hear this. I see he's kind of a rapper or something. He's got some music on the website. And here's some more pictures. Let's just put up some more pictures while we continue to talk about him. Prayers up. That's nice, Miss Jessica. We love you, Jen. Hashtag we are just one. Yep. Massachusetts mental health and BWH failed him. Right. And Joy wants to know, how do we contact you to offer support? I think if you go to the website, Joy, justonroot.com, I think there's a petition. He wrote the songs and he rapped them, she says. He has an IMDb too. Click on my IMDb and his. And here, a lot of support in the chat. My heart breaks for you and your family. Says, can't make this up. Oh, thank you, James, for your 10. James says, just a thank you. Thank you. Thank you for watching. Thank you for being outraged with me and being here for it all. And John Miller says, working on year 2. Thank you, Mel, for your work. Oh, thank you, John Miller. Technical Out became a new member. Welcome. David Shai says, Mel, first off, you are gorgeous years late, but wow, you are better than TMZ. This is beyond shocking. Proctor's involved. Arrest them all. Proctor, Fanning, Bukhenic, right, Jennifer? And maybe you'll get some answers now. Because you know what? These people in this chat are not going to stop. Right? There's still over 4,000 people here, and they are not going to stop. And I'm sad that it took me this long to cover this case, but everything happens for a reason. And we ain't got no quit. We ain't got no quit. And Aunt BB says, hopefully his sister will contact you. She has pictures and videos. She's here. She's in the chat. Amazing. Thanks, Aunt BB. 25 months. Aunt BB was my first member ever. Inray Celia Vialesti says, merch, Attorney Melanie Little showed me the papers. Attorney Melanie Little showed me the papers. Very good. I like it. I like it. Gray Space has been here for 11 months. How does a cop think a clear plastic gun is real? It's a great question. It's a great question. Becky gifted 5 memberships. Thank you, Becky. Thank you, Matrix Media 7777. Shout out to Matrix Media's YouTube channel. It's Matrix Media 7777. And Matrix Media, I don't know if it's he or she, sent me the 12-page report from Micah Morrissey on Justin Root, and we're going to cover that in more detail as soon as I'm able to put some more stuff together. Oh, and there's even a file. Thank you very much, Christina, for sending that to me. See, you guys are so on it. We're so collaborative here. And Stephen also sent me the public filings. You guys want to get into this? Are you ready to get into this? Are you outraged yet? And also, Angie sent me all of the documents. And so now I think we've got it all. I think we've got a lot of it. And video clips. Another viewer here saying Mike says it was a valid shoot and needs to be looked at through Graham B. Connor. If you point something that remotely looks like a gun at a cop, you sealed your fate. I don't know. He was on the ground. I don't know. I have to look into this more before I can even disagree with you right now, Mike, or agree with you. Disagree or agree. But the point of me bringing this up right now is that because of Proctor's phone extraction, could some more information come out now? Right? Could it? Is it just another example of cops covering for other cops? I don't know yet. I don't know. But if it was my brother, I wouldn't stop until I got better answers. I wouldn't. See what you guys think. Strange Credulity says, I was Alice for Halloween in honor of you. Oh, thank you. I love that for you. I love that for you. Technical Out says, with what's coming out in Proctor's text, this case could get reopened and should be. This tragedy hurts my heart as well as my legal soul. I know. Me too. Me too. Mine too. This was a half-assed presentation tonight, but I wanted to toss it out there to see if you guys wanted to do this with me, and it seems that you do. And so I think that we need to. Thank you, Liz Proctor's divorce attorney is here and says, Justin's sister Jen is in the chat. Thank you. Yes. You know what else they didn't look at? The EMT's testimony. So like whether or not he had a gun is also at issue here, you know? And this goes to Kelsey's case too. Did Kelsey point her gun at Noonan? Why? There's no body cam footage of what happened to Justin either. Is it just a coincidence? KLM, Jen Root is here. We are just one is her name. Thank you, KLM, for your 5. I found her. Jen Root is here. Justin's sister's in the chat. Thank you, Mozzie. I'm sorry, you guys, I'm a little late getting to these, but Jen is here. Welcome to our gang. It's Steph on the Cape. Thank you. I think you're going to like it here, Jen. We want to hear your story. Distracted Therapist says the clinic he was at is a part of is Vin Fen, worked for them for a decade. Justin isn't the first of our clients to be assassinated. Oh, really? Oh, really? Did Proctor investigate all of those assassinations? But it seems to me from the brief reading that I did here is that whatever Justin's issue was, his psychiatric issue was, they knew that he would say, I'm a cop, right? Or I'm law enforcement. That was part of his disorder, right? He was known to do that. And he was well known there. And apparently they never ran his plate when they were chasing him and they did the pit maneuver. They would have been able to find out more about him. I don't think they're very well trained in dealing with mental health or EDPs, right? And was Cox the Boston Police Commissioner in 2020 as well? I have so many questions. I'm horrified to hear that, Distracted Therapist, but I do thank you for your 10. And Trooper Reno was involved as well. Strange. Oh, really? So Garino was also involved in Justin Root? Why am I not surprised? Leave the drama at the door. It says testing. Good citizen became a member, but you've been a member for so long. Welcome back. And Bridget gifted 5 memberships and leave the drama at the door. Also, Cox was not the commissioner in 2020. Thank you. I mean, you know, does somebody owe somebody a favor? I mean, it seems to me, I don't know. I have so many questions. Thanks, you Matrix Media. Shout out to your channel. Justin's sister says he yelled twice. I am with law enforcement around 4 mental health centers. Yes, Garino was in charge of digital evidence. Of course. How many messages did he miss? What's going to come out in Proctor's text messages around this time? People are running scared. They're running scared. And if you do choose to play on the cesspool of Twitter and you find them coming for me, I think I might be getting really, really close to something here. What about de-escalation, Robin, right? Whispering Wind says, I can't wait to deep dive on his case. Let's stick together and do something about it. Yeah. You know why? Because you guys are amazing. You guys are amazing and you don't stop and you don't shut up. It doesn't matter who comes after you or who tries to post things about you. We're not stopping. Thank you. Everyone's into it now. We're into it. We're not done. What else? It's the rabbit hole. We're here. We're here for it. Yep. Some cops are itching to shoot someone. Yeah, I mean, I don't know. And Jennifer is here and she says, the deeper you dive, the more crazy it gets. And, you know, so many people are just like, oh, you know, they did everything right. Of course, they always do everything right, right? And ProHawk Beachay says, as a Norfolk County resident, I'm terrified. The deeper you dive, the more crazy it gets. When do we find out about the text? I don't know. When, if ever, will we find out about the text? We'll see. There's a lot of cases affected. There's at least 19 pending cases. But what about all the people that are already in jail? And I've been saying this for a long time. All the people that have been convicted based on what could have been biased investigations. Those 19 cases are not counting the people that are already incarcerated and convicted. Those are just pending cases that are coming up for trial. I don't know if all of them are murder cases, but I think a lot of them are. Yeah. Chloe's mom says it doesn't matter that Cox wasn't the commissioner at the time. He was still sweeping under the rug. He wasn't during John O'Keefe's murder either. And look at how deep he is in his case. Thank you, Michael. You sent me the video this morning about, I've been traveling all day, man. I've been on planes, trains, and automobiles. About Lally saying that Lally saying that Yuri and Proctor were at 34 Fairview, maybe on your next show. That's the original arrangement. Yeah, I'll take a look at it. Let me take a look at it. Dana says there is a use of force continuum that criminal justice academies teach, and that we are all tested on each and every year. It shows the levels of force. You might be able to find it online. Thank you. Wendy says Proctor's phone is going to tell us everything. And Big Old Dog says there's no doubt that there's stuff about Justin on his phone. Watch. Bragging. Jazzy's mom ain't got no quit. And Nebraska Jeff says they couldn't plant guns because they kept forgetting them while they were drunk in other cruisers. Right. Well done. Well done. Kristen says, thank you so much for noticing this case. I've been RT it on Twitter for his sister. I was horrified when I read about this several months ago. We can get attention on this, guys. Yeah, well, I think there are going to be, there may be some stuff found in there, right? Maybe. Whispering Wind says, I don't know how the state of Massachusetts is going to begin to fix this. Every single person in government and law enforcement sure seems dirty and a bunch of liars. Kiki says, word on the street is Commissioner Cox is going to be sued by at least 3 separate people. When I get more information, I will pass. Yes, 19 cases are compromised during Tude Proctor's phone, says Sherry Ann. Right, 19 pending cases that are coming up for trial. But what about other cases? What about other cases where people are already in prison and convicted that these investigations might have been biased? What about cases where charges were never brought that should have been? I mean, the tentacles of Proctor's phone go so far deep underground that there could be a lot of cases that weren't prosecuted that should have been. So many things. Local citizens should be terrified, says Joe Marr. Rampant corruption is terrifying. It is. But I don't, they did have a civil case, and I'm not sure what the status is. So I need to find out more information. Thank you. You sent an appeals opinion. I have that one. I think I read that one. That is the one that I read. And there was a dissenting opinion, right, by a judge. I think I read that one, and I need to know. Yeah, that's the one that I read. So I have that one. Thank you very much. And the case was dismissed in 2024. But did they take it up to the U.S. Supreme Court? This was the, like, I don't know where they went from here, if anywhere. April of 2024, the U.S. Court of Appeals for the First Circuit dismissed the case, but there was a dissenting opinion that said that he thought it should have gone to a jury. And that's the opinion that I like better. That's the opinion that I like better, because it talks about, you know, the things that the judge who wrote the opinion didn't look at, like the EMT's testimony and things like that. But before we even get to that, I'd like to do this chronologically. So I do thank you for that. That Jennifer has also posted on her website. I'd like to do it chronologically, the same way that we did Karen Reed, starting out with the initial investigative reports and then moving forward through the civil case, because they did a lot of depositions in the civil case too, right? Was Proctor deposed in your civil case, Jennifer? Yeah, they applied for a petition for a writ of certiorari in September 2024, but it likely was denied, because remember, they didn't even take Karen Reed's either. Thank you, Laura. Says, could the ADA not make a motion themselves to release Kelsey? And thank you for your voice bringing all this BS to us to join in your outrage. They could agree. They could certainly join in the defense's motion and say, we have no objection, Your Honor, to Kelsey Fitzsimmons doing urine testing. We have no objection to that. We also do not think that she's dangerous. They could consent. They're not going to. They're not going to. And really, Judge McCarthy Nyman did what she wanted to do, sua sponte. The Commonwealth didn't even ask for Kelsey to be incarcerated. So regardless of what the Commonwealth says or does or consents to, the judge still has discretion in the end. And she knows it. And she used it. And so now she's hopefully going to be overturned by the full panel of the SJC. But Magnolia Gypsy says they won't because they're afraid of this judge. They could have consented, and they kind of did. They tacitly sort of consented at the hearing when they said, we really don't have any objection other than, they did, but they didn't. And Pro Hoc Beaches says that Proctor is the corrupt common denominator. No. Tom Gully says, I marvel every day that there aren't pitchforks and torches at the DA's office and the investigator's office. Well, kind of are, right? Oh, that's very sweet. You just gave on the give, send, go. Says, I'm Gumby, damn it. Thank you. Well, Michelle, what charges could be brought, if any, on the cop whose bullet ricocheted on a bystander? Well, I don't know if there could be charges, but there's definitely could be a civil suit. There probably was a civil suit. I don't know that person's name, but I could look it up and try and find out if they did have a civil suit. It was probably quietly settled, I would imagine. Charges? No, because it seems to have been accidental. Could there have been charges brought against the police who shot Justin 31 times after he was already had been shot a couple of times and was, seemingly no threat and on the ground? There was a civil suit from the worker who had the bullet in the head for the valet. Yeah, the valet. Thank you. His name was Justin too? Thank you. Grateful Dead fan. 1988 was a great year. So I found some good shows last week for early November 1985 at the Centrum in Worcester, Massachusetts. I think I was there. Closest I could get to Canton. They encored with Broke Down Palace, Albert's House. The Albert's House shall forever be known as Broke Down Palace. 34 Fairview is Broke Down Palace. Well done. Well done. Yes, qualified immunity was something that was discussed, Kylie. It was something that was discussed in the appellate court decision. But again, we're getting ahead of ourselves, and that is one of the things relied on. But again, I haven't had enough time to do a deep dive into it. And there are so many people in the chat who know so much more about this case than I do, including Justin's sister. So I don't want to say anything. Have I seen that? Why do you keep repeating the same question over and over again? I have everything. I just have not had a chance to read it, Matrix Media. I have not had a chance to read it. As I said, this was a last minute add-on. Give me a little bit of grace, please. I will, as soon as I have time, read it all and go over it thoroughly. Tonight is not the time for this. Tonight is not the time for me to be able to do that because I need to be able to read it. I don't know. Why won't it let you hype this video? What's the deal? I don't know. I think is hype for smaller channels. I don't know what that means, actually. I think you have to wait until the video is over to hype it. I have no idea. I don't even know what that means. Hyping. What does that even mean? Happy 250th birthday of the Marine. Semper Fi. Semper Fi. Fare you well. Fare you well. I love you more than words can tell. Listen to the river sing. Listen to the river sing sweet songs to rock my soul. Do 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 do. Yeah, I need some rest. I've been on planes, trains, and automobiles today. And Elznana says, "Don't go to Massachusetts. We value your life. Thank you. Thank you so much." Miss Jessica says, "Melanie and Chad, I'll be on Justice Shay STV tomorrow at 6 p.m. for Veterans Day, mental health, and I'm airing unheard of Farwell's tea. That's amazing. Thank you for your service, Miss Jessica. And everyone watch Miss Jessica tomorrow on Just to Serve TV at 6 p.m. And thank you for your service. And Distracted Therapist says, any thought disorder has delusions of grandeur where you believe you are in law enforcement government. I saw police use suicide by cop defense at least 5 times in my 10 years. Thank you. Thank you for your 20. And Courtney says, they denied him aid while he lay dying, and then they got him several more times. Absolutely disgusting, and those involved need to be in jail. Yes. Thank you, Courtney, for tuning in from Canada and for your super chat. And let's see if we have any last-minute things here before we wrap for the evening. Thoughts, questions, comments, concerns before we wrap. There's a couple of other things I wanted to cover with you, but we will cover that tomorrow. Those of you who were timed out and blocked, I don't know what to tell you, except your timeout is probably over. And if you are blocked, I have to stand by my mods 100%. So it is what it is. If you're blocked and you send me an email with your channel and I don't get a bad report from any of the mods about something horrific that you said about me, I'll be happy to reinstate you. But, you know, this is what it is. You just got to be nice. You just got to not be a dick, basically. Just don't be a dick in the chat and you won't get timed out or whatever. Sent to Block Island. I don't know. That's the thing. All right. Stay cool, stay kind, stay classy. I'm going to come back tomorrow. I just don't know what time. It's probably going to be in the morning. And I don't know what we're going to talk about yet. Probably we'll come back to Justin Root if I can read some of this tonight, but I got a lot of homework to do. So let us do that. But make sure you have all notifications set and make sure that you have the subscribe button hit and don't act like a proctor. And well done. And there's Emily. Hi, Emily. Hi, I love you with all of my heart too. You're amazing. Yeah, I gotta go rest. I had a nice restful time away, but now it's time to get back to work. And so we'll be here every day until we get justice for everyone. For Justin Root, for Kelsey Fitzsimmons, for Aaron Spencer. And some people need to go to prison, like that kid in Oklahoma, whose name is escaping me right now. Jesse Butler. That kid needs to go to prison because, I don't know, you choked 2 girls out and raped them several times and beat them. And, you know, one of them was 30 seconds away from death. And you're going to the judge is just going to give you a little 1 year of therapy and you can walk free. He's not going to be rehabilitated. Okay. Because the next girl might actually wind up dead. Just like the kid that Judge Barbara Elmore let out, that 19-year-old, after he raped a child, and then she let him out on a little tiny bit of bail, and then he went and raped another child in another county in also Arkansas, and they are holding him on $500,000. So you know what? We're not going to stop, and we're not going to shut up, and there's a lot of shit that needs to happen, and we're going to make sure it does, okay? Not on my watch. Not on my watch. Stay cool, stay kind, stay classy. You can do it. I know you can. Thank you to the moderators because you guys are amazing. And I know this was hard tonight. Oh, I didn't see Dave this weekend. I was at a parents' weekend at college. I wish I saw Dave this weekend, but I didn't. But I do love Dave. All right. So not on my watch, not on your watch. Thank you, moderators. You're the best. I couldn't do this without you. And I will see you tomorrow. Okay. Make sure your notifications are set. And so we'll do this again tomorrow. Okay. Peace out. Love you guys.